This hearing is in the matter of case number CFI 080-2022 before Justice Michael Black. The claimant is represented by Charles Russell Speechlys, LLP. Lead counsel is Mr. Stephen Doherty. The first, second, third, and fourth defendants are represented by Hamdan Shamsi, lawyers and legal consultants. Lead counsel is Mr. Robert Whitehead. The fifth defendant is not present.
Thank you very much. So, Mr. Doherty, Mr. Whitehead has raised a jurisdiction issue in his skeleton, and it's probably best that we address that first, I think.
Yes, Your Honour, I'm happy to pick up a few points on that. I mean, of course, you'll note that the skeletons and the evidence presented for this hearing have not largely sought to deal with the question of jurisdiction, partly because no Part 12 application has in fact been raised. So I think our primary position on that is that any observations on jurisdiction may well be a moot point at best. But I think more broadly than that, touching on, I suppose, the headlines on jurisdiction, what we say is that it isn't really an argument in the context of this claim that withstands scrutiny. Reason being that on any analysis, there are several of the Article 5A JAL gateways that are engaged here. Obviously, we're dealing with the claimant being a DIFC establishment. We have, amongst other things, the letter of engagement, which makes it clear that the work being carried out was going to be carried on from the firm's Dubai office, i.e. its DIFC office. So we're already talking about a contract wholly or partly performed within the DIFC. More broadly than that, and obviously we'll come to this during the course of my substantive submissions, but the case concerns DIFC issued codes, so mandatory codes of conduct and codes of practice, but more broadly DIFC legislation which governs the conduct of law firms and of lawyers practicing within the DIFC. So on that view, this is a case arising out of incidents or transactions performed in the DIFC or relating to DIFC activities. But beyond that, of course, we're talking about matters over which the DIFC court itself has jurisdiction. So that's implementing the codes of practice and, where relevant, imposing sanctions or conducting investigations under those codes of practice. And because the DIFC court is the entity that's empowered to issue those sanctions, this claim obviously then touches on matters over which the DIFC court has jurisdiction in accordance with DIFC laws and regulations. So what we would say is that when one looks at primary jurisdiction under the gateways...
Sorry to interrupt, but your clients and its clients, which is the company, have submitted to the exclusive jurisdiction of the English courts.
Your Honour, that is what the provision is in the standard terms and conditions. Of course, that assumes that this case is purely about the construction of all rights under a contract. And again, for reasons which I'll come to in our more detailed submissions, this isn't a claim by the firm for payment of its fees. It's a question of its rights and obligations arising from a number of sources, some of which are contractual, but others which are regulatory in nature, premised on DIFC law, which are then underpinned in different instances by contracts. So we're not talking about a pure contractual issue in the first place. Now, of course, had there been a Part 12 application in this case, which we say there isn't, and of course you'll have seen that there are various substantive defences raised.
Let me tell you where my preliminary thinking is, because it will help you, I think, direct your submissions to where I see at the moment, and subject to your submissions, where I see the real issues. So your client, I mean, first of all, can I say that I have professionally the utmost sympathy for your clients from the outset. Your clients are faced with a dispute between essentially two groups of shareholders within their client. Their client is the company, Grand Valley, and this looks very much like, from my reading only of the materials put before me, a family dispute with Mr. Abdullah on one side and Mr. Mohammed on the other as to the control of the company. Now, I can't decide that issue. It is sub judice before the Dubai and I think Sharjah courts. I couldn't express a view on it and shouldn't express a view on it. But what it does mean, and I see the chronology, on the one hand, in October, what I might call the Mohammed side, through Mr. Al-Arabiet, have asked for the documents in the case and want to give your clients instructions. On the other side, on I think it was the 9th of November, wasn't it, on Mr. Abdullah's side, they have said don't take instructions from the other so-called owners. We are the owners and we are seeking to establish that in the courts. Don't give them any documents. And you're between a rock, or your clients are between a rock and a hard place, because they obviously have duties of confidentiality. And if in the event it's found that Mr. Mohammed's side did not gain control of the company properly, any documents they would give them would be in breach of their duty of confidentiality. In addition, they are owed rather a lot of money. So they are regulated not just in the DIFC, but also by the Solicitors Regulation Authority in London, being as an entity themselves a London limited partnership, regulated by the Solicitors Regulation Authority. Rule 4.1 of the SRA rules is pretty clear in saying that if a solicitor's firm really doesn't know who is authorized to give instructions on behalf of their client, they can't act. And again, my preliminary thoughts were, whilst it's a matter entirely for your clients, I think, rather than for this court, given the contents of Rule 4.1, they ought to be considering simply resigning from the retainer altogether. That being so, the question then arises, well, what about the documents that they hold? They appear to have a contractual lien over those documents, and this is where we come to the jurisdiction issue. If a party wishes that lien released, it's going to have to go to the English courts to get that done. And there are pretty clear rules in England about how you get a lien released. They're going to have to pay in all of the sums due to your client in order to get the lien released under the English rules. So that's where I stand at the moment. I don't at the moment see a role in any of that for the DIFC courts.
Well, yes, perhaps the starting point for addressing that would be this, Your Honour, which is if one looks at B38, which is part of the provisions of the terms of engagement.
So B38.
Yes.
Yeah. Okay, just give me 1 second and I will get there. Yes, I have it.
What you'll see at the top of that page is provisions, two assumptions under the letter of engagement. The bottom assumption being that you wish the work to be carried out at this office, Dubai, not one of our other offices.
Yes.
Now that's relevant, we say, because if this was a scenario in which CRS London had been engaged to perform this contract, and all of the work is being carried out with the London office, albeit that the dispute has some connection with Dubai. That might well be an argument that could be advanced in favour of why this issue would need to be addressed in another jurisdiction in England. But the reality is that we're dealing with work which was expressly under the terms of engagement being carried out within the DIFC. What that means is that in carrying out the work, the firm is subject to mandatory codes of practice issued by the DIFC court. But what we say is that the existence of those codes of practice is not a trivial matter. And I'm sure Your Honour is aware that the DIFC court, acting through its registry, can and does issue sanctions against individual lawyers and law firms for breaching those codes of practice. And that is very much something which arises as a matter of DIFC law rather than UK law.
But we're not dealing with, Mr. Doherty, we're not dealing with a disciplinary matter. We're dealing here with a retainer and the relationship between a solicitor and its client being the company.
Yes, Your Honour, I understand that. I think what we're saying is that this is a case which involves multi-layered issues which are not purely contractual. They relate not only to what contractual right exists on the part of the firm to act, but also what regulatory obligations are placed on it as to how it should act. And those are laws which arise in the context of the DIFC as a jurisdiction and which apply to the firm as a DIFC entity. So I think what I was going to come to say earlier was that had this been put as a Part 12 jurisdiction challenge, as one might have expected, if that's going to be the primary basis on which the defendants are challenging this, the response, of course, would be that the existence of a exclusive jurisdiction clause is not in this jurisdiction determinative of whether or not the DIFC court has jurisdiction. And there's an established line of case law on that. It's the Carafi case, Orion Holdings and so on, that followed it.
No, I was counsel in that case, so I remember it.
The point there being that there can be compelling circumstances in which the court can look beyond the existence of an exclusive jurisdiction clause. And I think that the example in that case is where you end up with fragmentation of proceedings, amongst other things. And one can see there being a case for that here. So, for example, if firm was to go before the English courts talking about its regulatory obligations, what would likely be met with is the arguments being made here that, well, this firm is subject to some form of Dubai regulatory authority. I think my learned friend suggests it's the Government Legal Affairs Department. We say the relevant codes of practice are the DIFCs. But one could see the English courts equally taking a view that, well, that's not really an issue for us. We'll deal with one of the issues, which is purely contractual. And then you end up with a sort of husk of an issue that can end up coming before the DIFC courts. And what one would then really get into is asking the question, well, is there primary jurisdiction for the DIFC courts to consider this? And we say that there are under at least 4 of the JAL gateways. So that's DIFC establishment, contract wholly or partly performed in the DIFC, transactions performed in the DIFC or relating to DIFC activities, i.e. the carrying on of legal professional services within the DIFC, and issues over which the court otherwise has primary jurisdiction. So that's sort of regulatory and sanctions-based issues which this case engages. There is, of course, beyond the DIFC itself, a nexus with other questions of, I suppose I can put it, Dubai law, and you'll have seen in my skeleton we make submissions about the UAE Penal Code. Now, of course, criminal matters aren't issues that can be dealt with in the DIFC, but if one were to go on to look at questions of which forum was clearly and distinctly the appropriate forum, so if you're dealing with forum and non-convenience types of arguments, one can easily see there being legitimate grounds on which the DIFC court would assume jurisdiction over this issue as compared with the English courts, and that would be not only due to the elements of this dispute which touch on specific DIFC law, but also, of course, the DIFC's comparative familiarity with matters of onshore UAE law as compared with the English courts, who would be more reluctant to premise any findings based on onshore provisions or to see the relevance of those onshore provisions. So what we would say is that the primary JAL gateways are engaged on multiple fronts. But if one were to actually look at this application in the rounds, that's where these events are unfolding, the parties involved, where the parties are situated, where it's expected that the work is going to be carried out, how the parties have considered that the firm is regulated, intended to be regulated, that this would be the sort of case that the DIFC court ought to assume jurisdiction over anyway, because it's a more convenient forum for a whole host of reasons than the English courts would be. So, as I say, the established line of case law in the DIFC is that the exclusive jurisdiction clause is in no way determinative of the question of jurisdiction, and there are a host of very good reasons why we say that the DIFC court should assume jurisdiction in this case, why it should also take the view that no jurisdiction challenge has been made. And I would add to that, of course, we do see substantive layers of defence coming from my learned friend, which in some instances can be seen to be conceding points on jurisdiction. So, for example, engaging on the merits of a summary judgment or something like that can be seen as consenting to the court having jurisdiction to deal with those issues. So for those reasons, we do say that the DIFC court has jurisdiction in this case, and we can proceed. I mean, it may well be that some of those grounds come out when we go through the evidence that I intend to present to Your Honour this morning. It may well also be, given that I suppose it hadn't necessarily been anticipated that jurisdiction was going to be the primary issue in the hearing, but I'm sure that there are issues which, if you have any residual concerns, can be dealt with in supplementary submissions dealing with that question. But for our purposes, we're content with the submission that the court can proceed.
No, I thank you very much. I understand that, and no doubt Mr. Whitehead will address me in due course on that. And again, I hope to be totally transparent about my thinking, so that you can address it as you feel necessary, both of you. As I said before, obviously one has great professional sympathy with somebody who has conflicting instructions. And I would like very much to be able to be in the position to sort the mess out. It may be that jurisdiction in relation to what you're asking me to do, and we'll come to the merits of that obviously in a moment, is not the real issue. The real issue is jurisdiction a little further down the line, particularly in relation to the second element of your submission in relation to fees, and where any issue as to fees would have to be determined given the express terms of the retainer. But we'll come to that in due course, and it's a bridge we will cross if and when we reach it. So thank you for those sort of preliminary observations, which I know took you slightly off course. If you'd like to proceed as you were planning to proceed, that would be very helpful. Thank you.
Yes, Your Honour. At one point, I should say I wanted to make clear as well, and this I think will come out through my submissions. We fully accept, for what it's worth, that the questions which are in the underlying dispute, so that's what's currently ongoing before the UAE courts, the question of ownership, that is something which we're not asking you to make any findings on. It is something which falls within the jurisdiction of those courts.
You couldn't tempt me to make any findings on that.
But I wanted to be clear that the only relevance for present purposes is the fact that those proceedings exist. We're not seeking in any way to prejudice, nor do we make any submissions which seek to express a view on the underlying merits of those proceedings. It's simply for the court's information. And similarly on the question of fees, as I've already said, this isn't a claim for payment of the fees. It's seeking a declaration which deals with mixed questions of provisions of law as well as provisions which have a contractual underpin. But hopefully, as I say, we'll get to that in due course as I go through my submissions.
Yes, because I mean, what my real concern is, what are you asking me to do, and is it and is what you are asking me to do an appropriate use of Part 8 and the court's power? I was going to say jurisdiction, but it's jurisdiction. It's a power in the sense, it's jurisdiction in the sense of power, and the court's power to make declarations. Again, being totally open about it, at its most basic, you're making me, you're perhaps inviting me to declare that which is obvious. I can't, in any sense, enter into the merits. All I can declare is what you've already said the applicable rules say. I can only then enforce them in the context of a dispute which has not yet arisen as to your client's regulatory obligations, it seems to me.
I think we perhaps see it slightly differently, because what we're not asking the court to do is necessarily to say that we have not breached our obligations. That would be taking it into the sort of professional conduct realm
That's fact
of an issue that would be dealt with. Yes, that would be fact sensitive, and the same would go for questions which we're not asking the court to determine. For example, when it comes to fees, are fees properly incurred, that sort of thing. Those aren't the issues here. The issue is whether, on the basis, on the premise of undisputed fact, there is a legal right or a legal obligation which operates in a way that means that the claimant should not act on instructions until the UAE claims have been determined. So that's the first question. Then, of course, the second question is effectively the same premise. Is there a right or an obligation not to act on the instruction to provide documents unless and until fees have been paid?
Well, the second one
that would
is,
be the
is the effectiveness of your contractual lien.
Yes and no. That's one part of it, but you'll have also seen that we refer to DIFC codes of practice.
Yeah, I mean, the issue there
is
whether the codes of practice are, in high-level terms, saying that if you do assert a contractual lien, these are the regulations, but they are, if you like, subservient to the fact as to whether or not there is a contractual lien, rather than providing that there is a lien in every single case. You're going to have to address me on that.
Yes, I think again this should become clear as we go through. One can view issues 1 and 2. So issue 1 is effectively a question of legal and professional obligations which contain what one could view as a consistent contractual underpin. And the second issue might be viewed sort of as the inverse of that, I suppose, that there is a primary contractual right supported by a regulatory underpin. But I suppose coming back to the point in jurisdiction, we say the fact that there is the interaction of the two on both issues is one of the reasons why the DIFC court rather than the English court would be the appropriate forum, the clearly and distinctly appropriate forum for the resolution of this dispute, which involves those combined questions. as I say, that's probably quite a lot by way of introduction as to where I'm going. I think the way that I propose to tackle it is, first of all, to take some time, because I think it's important to fully appreciate the context, to go through the background facts and to take your honour to the underlying documents which make it clear why we say the claimant is between a rock and a hard place. And
well, I don't think you need to do that, frankly, because the only thing that I need to know is that there is a dispute, as I said, between one side of the family, as far as I can see, and another side of the family, as to the control of your client. You're receiving, your clients are receiving contradictory instructions from each side, and that will not be resolved unless and until the proceedings in the UAE courts outside the DIFC are completed. I mean, I don't, in a sense, I don't need any more than that.
Yes, Your Honour, I suppose it's more because the facts do interact with the professional obligation side of things in a multitude of different ways. I mean, really, the nub of the submission that we make is that there is obviously this dispute concerning authority, and that's one of the primary reasons why the confidentiality obligations are triggered, meaning that we are stuck between a rock and a hard place with those competing sets of instructions. There are broader aspects to the background which may well be relevant to other provisions of the code of conduct. So that's, for example, dealing with questions of dishonesty or illegality.
Well, I can't go into that.
No, of course one can't go into defining that. I think that the relevant question isn't resolving those issues. What might be relevant is that there is sort of a core of documentation which gives rise to there being, I suppose, a founded dispute or a founded set of issues, which mean that the manner in which the claimant acts may well be infringing on its requirements not to perform dishonest conduct or illegal conduct, or conduct which brings profession into disrepute and that sort of thing.
No, I mean, I really think that that's a bridge too far. I really do. I think the only relevant issue for me is your client receiving conflicting instructions from two sets of people who claim to be in control of their client, and that's it. I can't make any judgment about which of those two parties gives rise to a risk of dishonest conduct. That would be to go into the merits in a way that's quite impossible and quite impermissible in my view.
Yes,
I don't think you need any more than the conflict.
No. Yes, Your Honour, I'm not going to push against that. That is the primary case, is the conflict that puts us into this scenario. I suppose what we're saying is that the background facts simply show us that the conflict is a legitimate one rather than a spurious one. But it sounds to me as though,
well, it is legitimate because it's being adjudicated. It is legitimate because it's being entertained by the courts outside the DIFC. So they will come to a conclusion.
Yes, Your Honour. Do I take it that on that premise that you don't? Are there any particular sort of issues arising from the facts that you wish me to go through, or are you content with how the underlying issue sits and your understanding of it?
I am content. First of all, I've read it all anyway. And secondly, I don't think it's appropriate for me to get involved in the least in the underlying dispute, which is being determined by other courts.
Yes. Okay. Well, in that case, what I propose to do is to move, I suppose, beyond the underlying substantive dispute. That's the ownership dispute.
Yes.
To the interactions of the parties and the correspondence issuing the instructions, which we say are relevant, I suppose, to the what one might view as the sort of next layer of jurisdictional question, which is about the court's discretion to award a declaration or to provide declaratory relief over the issues. And that sets the context to why we say these Part 8 proceedings were necessitated in the first place. Now, I won't go to all of this. Some of it's been set out in Ms. Sheffield's first witness statement, but also highlighted in my skeleton. But of course, you'll recall that Ms. Sheffield, the firm, first discovers the issue in August 2022, and that's through discussions that take place with the opposing party in the LCIA arbitration. What we then have on the 7th of September, I won't go to that email, but it's a B144 if you do wish to look at it, is the first communications from the new owners and managers, or the purported new owners and managers, which is an email from Mr. Rajesh Sharma, Bath Grand Valley, attaching a letter which is predated, but this is the date it's received. So it's a letter of 25th of August. And that's the first time we get the issuance of the instruction, first of all, stay the LCIA arbitration, and the second instruction to provide copies of all case documents. The initial response to that, again, I won't take you to this particular document, but it's at B147 for your note, effectively is to go back and ask who Mr. Al-Arabiat, the fourth defendant, who's issuing instructions as Grand Manager, asking what capacity he's acting in, and asking for a number of documents that had been requested by the LCIA tribunal. And then we have a further exchange of correspondence. Again, it reiterates the instruction. And then if we start at B152, which is the set of exhibits to Ms. Sheffield's first statement.
Yes.
We have the first letter in which a substantive response is provided in relation to the instruction. And it's the final three paragraphs, really, the materials. We're aware a dispute has arisen concerning the ownership of Grand Valley. In that context, we understand their proceedings to appoint a judicial receiver. We await the outcome of those proceedings. We confirm the firm will act in accordance with any final and binding judgment. So the position, really, from the outset is that the claimant is going to abide by the decision of the UAE courts, whatever that outcome happens to be. That is then met with the formal legal notice, if one goes over the page, to B153. And this is a notice issued not only against the firm, but against two of its employees. So we see at the bottom of that page references to Ms. Sheffield as the notified party, and then over the page to Mr. Davis. And then at B154, we see the statement of what the legal notice is purporting to set out. So it's first, submission of the application to stay. So that's the instruction. Second, it's a slightly broader request to provide copies of all documents, not just in relation to the case, but all documents in possession of the notified parties, relating to notified parties in general. Third and fourth are specific requests for documents in specific cases. And then fifth, it says, in the case of failure of the notified parties to comply with the foregoing within 5 days from the date of this notice, the notifying party shall take legal action against the notified parties for the significant loss that will be suffered by the notifying party as a result of such breach, and for the professional breach committed by the notified parties in violation of the provisions of the Advocates and Legal Consultants resolutions and regulations in the Emirate of Dubai. So we have a couple of points in there which are relevant to the reason that this claim became necessary. We have, of course, a firm and concrete threat that if you don't act, we are going to take legal action, which immediately places not only...
They haven't done that.
Well, they haven't done that, but perhaps the precise reason for that is that these Part 8 proceedings have been instigated with the intention of preventing that step being taken, which is, we say, and I'll come on to this in the context of what the law says about awarding declaratory relief, but it's one of the reasons one can legitimately go to the court on a Part 8 seeking a declaration, is to try and prevent precisely the scenario arising where a party is threatening legal action and the other party needs to go to the court to find out what steps it ought to take to try and prevent itself from finding itself subject to that sort of litigation. And that's not sort of new or novel use of the Part 8 or of the declaratory jurisdiction of the court. That's something which, as I'll come to, is stated in a case from, I think, 101 years ago. So we say this falls squarely within the proper use of the jurisdiction is really the point there. And the other point is that, of course, when it comes to the question of the court's jurisdiction, what we also have at the outset being contemplated by the defendants is that the legal issues that it is going to raise in any action don't touch on your obligations as an SRA regulated authority, but what it's talking about is professional breaches committed by the notified party in violations of Dubai laws. So what's being contemplated there isn't some reference to the SRA or some reference to the English courts. We are directly being threatened with legal action in Dubai. If we can then skip to page B163, slightly forward. We find the response issues that legal notice. So this is a letter from the claimant on the 27th of October. It raises a number of different issues. I'm not going to go through them all. The first element of this letter that I'd hope to point out is over the page at B164. In the middle of the page, where if we were in the old days and we had a hole punch, probably where the first hole punch would have started, beginning notwithstanding the above.
Yes.
So you're saying, notwithstanding the above, we're not in breach of our professional obligations to Grand Valley. First, this firm is a DIFC registered entity, and we've complied with the DIFC Court's Code of Best Legal and Professional Practice at all times. The notice advances no identifiable argument in breach of any such obligations. So we have there the assertion that the relevant regulatory framework governing conduct here is a DIFC framework. So that, I suppose, deals with two issues. One, it's the potential assertion that this is a matter for the Legal Affairs Department, but also it highlights the fact that both parties are clearly contemplating that this is going to be some kind of regulatory issue in Dubai, whether it's onshore or in the DIFC, rather than being anything touching upon the English court's jurisdiction or the jurisdiction of the SRA. The second point of this letter is the penultimate paragraph still on this page. It says, further, we're entitled to retain all Grand Valley's files and documents. Whilst there's money owing to us in any matter, we've issued multiple invoices. With Rajesh Sharma, we're entitled, pursuant to both the terms of engagement and paragraph 8 of the DIFC code, to retain the documents and information requested in the notice pending final settlement. So again, a couple of points. Obviously, it's flagging up the exercise of the contractual lien, but it's also saying that this right to not produce the documents, or this obligation indeed, not to produce the documents under the firm's confidentiality obligations, isn't solely contractual, but we're dealing with mixed questions of contract, but also of a legal framework which is specific to the DIFC. And then the final paragraph of that page is reiterating the point that the claimant was going to comply with the decision of the UAE courts, whatever that might be. So there's furthermore, as we've previously explained, in circumstances where we're aware there's an ongoing dispute as to the rightful ownership and control of Grand Valley, our professional obligations. So again, that's professional obligations, not our contractual obligations, which include clear obligations of confidentiality, prevent us from providing the documents and information requested by you until such time as that is resolved. Then it says, once the dispute is resolved, this firm will abide by the determination of the courts. And then finally, over the page to B165, with as above, please therefore confirm by 31st October that the notices are withdrawn. To the extent that the notices are not withdrawn, this firm reserves its right to seek appropriately from the DIFC court. So again, what's being said here is you've issued this notice. Here's why we consider, based on our regulatory framework in the DIFC, we can't act on your instructions. Please withdraw this notice, threatening us with substantial damages. Otherwise, we won't have any choice but to go to the DIFC court seeking relief for that. So just touching on that point, the claimant's position, the reason it's seeking the involvement of the court and the direction of the court, is that a claim before this court is necessary and was going to be necessary unless those legal notices were withdrawn, because otherwise the counterfactual scenario was one in which it was being threatened with legal action, which was contemplated at that time by the defendants as being something that was going to be a claim for substantial damages. Unfortunately, that, of course, as we know, didn't lead to the withdrawal of those formal legal notices, but prompted a purported notice of termination. That was in the 31st of October. The document itself is at page B167, which again, I'll ask you to look at, because there are a couple of important points.
Sorry, give me the reference again, please.
Sorry, yes, it's B167, so just a couple of pages over.
Yes, I have that.
And again, the significance here is that what is being said, or the key significance here is one of the things being said is that unless you comply with our instructions, we're going to suffer damage and we're going to hold you liable for that. I'll go through the main parts of this letter. The first one is at the bottom of the page. Paragraph beginning, it became evident that our efforts to maintain professional and productive communication with your firm proved futile. Thus, we are writing this letter to officially inform you we've decided to terminate our current representation agreement immediately in accordance with the stipulations of DIFC Courts Code of Best Legal Professional Practice and over the page, the stipulations of DIFC Courts Order number 4 of 2019, Mandatory Code of Conduct for legal practitioners in the DIFC courts. So we don't have there is an assertion by the fourth defendant or the first defendant saying we are terminating the letter of engagement pursuant to clause X of your standard terms. What they're saying is because you have failed to adhere to your professional obligations arising under the DIFC courts legal framework and its codes of best practice, we are terminating this engagement. The next paragraph refers to finding another attorney to take over, but if you then look at the paragraph after that, it says we are terminating our agreement because of your lack of communication and carelessness in achieving the aforementioned instructions in the aforesaid arbitration case, including your failure to provide us with a full copy of the case's documents. You have unfortunately not only to fail to handle the company's matter with due diligence and care, but to our surprise, you've turned the tables as we've been requesting the above mentioned request for a long period of time, despite the matter being time sensitive and critical, but no productive response has been received from your side. So again, this is framed in the context of breaches, supposedly professional obligations owed as a firm practicing in the DIFC.
Yes.
And then the final document I take your honour to is at B169.
Yeah.
And this is really for a matter of record. This is what one would say is the conflicting instruction, the instruction coming from the fifth defendant, refuting the transfer of ownership explaining that court proceedings are ongoing, and that there's an instruction not to act on the instructions that had been received. And that, again, for your reference, is supported by a legal notice at B171.
What is meant to be the effect of these so-called notices?
And so really that's, I suppose, confirmation of the observation that you made at the outset, which is the claimant being put into a position where it's stuck between a rock and a hard place, because it has, on the one hand, instructions asking it to take a particular step stated to be for on behalf of the first defendant, and we have another, which is the polar opposite of that, saying you're formally instructed not to take this step.
Yes.
Which really comes back to what the underlying rationale of these proceedings is, and also the question of how.
Sorry, can I just have a read of this? I haven't read this legal notice before, so let me just.
Certainly.
So it's the therefore on page 172. The notifying party notifies you it's important not to fulfill the request stated in the legal notice. Take all legal action against the notified parties. Okay, all right, then I see.
And the other point of the notice that you may wish to highlight is paragraph 6. So that's on the page I think you're looking at, B172.
Yeah. Yes, I see
so
that.
The notifying commence said notice can cause irreversible gross damage to the notifying party in the present case. So similarly, what we have is, coming from both angles, substantive threats of litigation, which is said to give rise to gross damage or substantial damages, some large and valuable claim, which presents obviously a real and immediate risk, not only of those substantial damages actually being incurred because of some breach of professional obligations within the DIFC, but also the risk of there being either one set or two sets or multiple sets in multiple jurisdictions of costly, time-consuming litigation dealing with those issues. And really the point is, when presented with that type of scenario, what might a prudent, responsible, conscientious law firm do? And whilst it is a largely impossible situation from the point of view of satisfying those competing instructions, there is a responsible path that we say a firm presented with those circumstances can charge. And that is precisely the reason that these proceedings have been instigated, these Part 8 proceedings, because we've been presented with a factual scenario which is difficult to resolve a way out of, which is not a disputed factual scenario, and is one in which the claimant is right, we say, to seek some formal directive from the court as to how it should act in order to prevent these claims arising. And really, absent a court order in those circumstances, there's no obvious alternative resolution to that issue, because, of course, until the UAE claims are resolved, the firm would have no way of knowing which of the competing parties was the authorized party issuing it instructions. I don't think it's as simple as saying that one can simply withdraw from proceedings, because that doesn't really deal with the scenario where a client wants its documents back, and another client is telling you under no circumstances provide these documents. So that's not really an answer either. So we have an indeterminate period of time until the UAE courts have resolved the question of ownership. Until then, the firm is effectively stuck in limbo, not knowing how it can act, and simultaneously bearing an ongoing risk of litigation being instigated on multiple fronts, alleging that it's caused substantial monetary damage to both of these parties. So, Your Honour, that's the context which I think brings me then to the relevant legal and contractual rights that we rely on. And as I say, you're aware there are the two questions. There's whether the legal and regulatory obligations governing the conduct of law firms in the DIFC mean that the claimant is entitled or required to refrain from acting on the instructions that it has been issued with until the resolution of those UAE claims. And the second is whether, and this is really a distinct question, the terms of engagement or professional obligations or both provide a basis for asserting a lien over documents where invoices are unpaid. So I'll deal with those in turn. As I said, the notice of termination and the letters before then issued by the fourth defendant, purportedly on behalf of the first defendant, expressly rely on the fact that the claimant is a law firm practicing in Dubai, and latterly make specific reference to the fact that it's a law firm practicing in the DIFC. And as such, it was invoking its right to issue the instructions and for the claimant to act on those instructions based on the DIFC's mandatory code of conduct. And so that's order number 4 of 2019. And as I said right at the outset, those codes, as Your Honour will be aware, aren't hollow, they aren't meaningless, and they aren't without teeth. They can and do form the basis on which the court issues sanctions with respect to issues misconduct. That can be financial penalties. It can also be suspension of a lawyer's entitlement to practice. So they're serious codes with a serious legislative underpin issued for a legitimate and serious purpose. Those codes are in the bundle.
Mr. Doddier, I said that I was just going to have to rise for a couple of minutes just before 11 UK time. Would you bear with me while I just deal with a personal matter I have to deal with? And I will literally be no more than 4 or 5 minutes.
Yes, absolutely not a problem.
Right, you stay online. I'm just going to switch my camera and microphone off, and I'll come back online as soon as I've dealt with it. Thank you.
Thank you.
Thank you very much for that. I'm able to come back online. Thank you, Mr. Doherty.
Thank you, Your Honour. Where I was going to go was to the code, which is the bundle at F, page 122, which is tab 9. I don't know whether you're working off on PDF with just the page references, or whether you're on case lines.
I'm on case lines, but what page did you want?
F122 is where we find the code.
Yep, got it.
The relevant provisions are, first of all, over the page at F123, paragraph 19.
Yes.
Which is practitioners should keep information communicated to them by their client confidential, unless such disclosure is authorized by the client, ordered by the court, or required by law. This duty continues even after the practitioner has ceased to act for the client. So just pausing in that final sentence, that really comes back to the question of how termination withdrawal doesn't really provide a straightforward answer to the dilemma that is presented to the court in these palliate proceedings. And then paragraph 22J, which is over the page, which I won't linger on for reasons Your Honour has already indicated, but this was simply the provision I'd highlighted in my skeleton about practitioners not engaging in conduct involving dishonesty, fraud, deceit, or deliberate misrepresentation. So as I say, when we make that submission, we are not trying, we don't take a stance on the conduct of any of the defendants, nor are we trying to say that that's what the conduct is, but from the, really one has to view this from the lawyer's perspective of ensuring that they are not knowingly or unwittingly becoming involved in conduct where there are grounds to suspect that there might be issues. So it's not something which we are saying invokes dishonest conduct of any particular party. But what we have, of course, is a scenario here where we have two adverse parties, each of whom asserts that they have the authority to act on behalf of the company, and a situation where clearly one of them is right and one of them is wrong. And so the question from the lawyer's perspective is whether it acting now, as opposed to later when those questions are resolved, it is putting itself in danger of infringing paragraph 22J. I hope that makes sense. As I say, to a large extent, those provisions ought to be self-explanatory. They're supplemented by a non-mandatory code of practice, which I'm going to come to in just a moment. But of course, it's worth bearing in mind that the primary position under the code, which is itself a DIFC issued mandatory code, it has legal effect within this jurisdiction, provides, regardless of anything that is said in the underlying terms of engagement or the contract between the parties, that practitioners shall, so they must, keep information confidential unless that disclosure is authorized by the client or ordered by the court or required by law. Now, the latter provisions don't apply here because we're not talking about a scenario, at least not yet, where a court has ordered the production of those documents and there's no other provision of law. So the only way one can get to a properly based disclosure being made by a law firm in line with mandatory confidentiality obligations are where the firm is satisfied that those disclosures have been authorized, which is really where the problem creeps in this case, because there's, until the resolution of the UAE claims, no way for the claimant to establish that either of the competing sets of instructions that it has been issued with are properly authorized by the first defendant. And what we would say is that that provision of law alone, ignoring the contractual provisions, is enough of a basis not only for the court to have jurisdiction in this case, because we are not talking about any issue which is impacted by an exclusive jurisdiction clause, but also why it would be proper for the court to exercise its discretion to order the relief sought. If we then go to F126, we find a number of provisions which I'd highlight in the DIC Court's Code of Best Legal Professional Practice. First of all, if we go to F126, I just have a few observations to make on how one ought to view these provisions, how they operate, how they apply. So we can see in the middle of, I think it's in the middle of the second sentence really of the first paragraph, we find reference to the fact that the code should set the standard for professional conduct of all lawyers who operate within the DIFC, whether they're licensed to conduct business in the DIFC or authorized to appear as an advocate before the DIFC courts. So again, one might think that that can touch on questions of jurisdiction because we're talking about a code which is specifically applying within the confines of the DIFC, whether you're regulated, as of course the claimant is here, or not. So if you're an onshore law firm or if you're an advocate based in London, you're still expected to adhere to this code. Paragraph 2, just below, points out that I suppose is distinct from the mandatory code of conduct. This isn't a document which yet holds regulatory status. But what it still says is that a failure to adhere to the code is likely to have consequences for that lawyer or firm in the event that such conduct becomes relevant to any case or hearing that comes before the DIFC courts. And what paragraph 2 goes on to say is that the code is a benchmark for behaviour and professional conduct, and that in all likelihood it would in due course become incorporated into the mandatory code. Now, whilst that hasn't happened yet, in my submission, probably a reasonable way in which the court can view this document is as a set of formal, albeit non-binding guidance, which is intended to inform the way that the mandatory code of conduct is intended to operate. So where, for example, you have provisions in the mandatory code of conduct and one wants to shed light on how the legislator intends those to operate, one can go to the code of best practice and look at what it says, amongst other things, about authorization by clients, acting on client instructions, what it says about confidentiality, what it says about issues touching on lawyers engaging in dishonest conduct, those sorts of things. So that's why we say one should read this document. The relevant parts to this Part 8 claim are, first of all, paragraph 7.4, which is an F127. And this is about authority. So the lawyer shall ensure that the agent giving instructions on behalf of a client has the required authority to do so, and in the absence of evidence of such authority, the lawyer shall, within a reasonable time thereof, confirm the instructions with the client. So that's a provision which we say can inform the court's view of the mandatory provision. So that was paragraph 19, part C of the Code of Conduct, because that refers to disclosures needing to be authorized by the client. And if one says, well, what does that mean? We can go to the Code of Best Practice and say that if you're being authorized by an agent, you need to ensure that that agent has authority. And in the absence of such authority, the instructions need to be confirmed directly with the client. And really that's a roundabout way of saying none of that is possible in this case. The next provision just below that we say is relevant, as I've just formulated it to your honour, as a lawyer should not knowingly assist his client in any activities that are illegal for the lawyer or his client. So again, the words we would emphasise there are for the lawyer. What we're keen to ensure here is that the lawyer itself is not engaging in something which could be seen as or could become unlawful conduct. And that's not to disparage any of the parties here. It's simply to say that one of them has to be right and one of them has to be wrong. So if we choose to act for one and not the other, there is at least a risk of that sort of provision becoming engaged. Over the page, paragraph 7.6 is similar, which is a lawyer must not act where his client's instructions will involve, and perhaps this is a more, I suppose, salient sub-point of the previous paragraph, but involve the lawyer in a breach of the law or a breach of professional conduct, nor shall he advise his client where he knows that there are reasonable grounds to believe that the client is requesting advice for an illegal purpose. Now, the issue there is that even if one takes this outside the scope of being potentially illegal conduct, is it conduct which is a potential breach of professional conduct? So again, in the example where we've got two agents authorizing, on the one hand, the release of documents, and on the other hand, saying don't release the documents, one of those is going to be right and one of those is going to be wrong. And if the claimant chooses to act, it puts itself in a position where there is at least some chance that it will be breaching its professional conduct obligations, i.e. its confidentiality obligations to its client. because it will have disclosed information without the authority to do so. Paragraph 12.1, that's at F130. Sorry, final point, I suppose, on paragraph 7.6. That might also be relevant, Your Honour, to the provisions of the UAE's penal code, which I'll come on to, and I can take you to those terms. But in effect, what they suggest is that if you have been provided with some form of commercial secret in the course of your engagement as a professional, and you disclose that information without authority, that can give rise to criminal sanctions in the UAE. So in the context of paragraph 7.6, that's the sort of disclosure which could put the lawyer in a position where it is behaving unlawfully if it chooses to act on one set of instructions. Sorry for that slight divergence. Paragraph 12.1, page F130 at the bottom of the page. A lawyer shall not in any way, directly or indirectly, disclose any confidential information which the lawyer receives as a result of the retainer, or disclose the contents of papers recording such instructions, unless with the consent of the client or where required by law or order of court. So again, that's a provision in the guidance which says the best legal practice is, as we've already seen set out, paragraph 19 of Part C of the Mandatory Code of Conduct. Over the page to F131, paragraph 12.8, towards the bottom of the page. A lawyer is under a duty to keep his client's business and affairs confidential and to ensure that his staff do the same. It's the responsibility of a lawyer to ensure compliance unless the lawyer is under a legal duty to disclose such information. So again, it's a little bit more flesh on the bones of the confidentiality provision set out in the Mandatory Code. And then we've also referred over the page, I would take you to paragraph 14.4, which is more or less a verbatim repetition of what's in the Mandatory Code of Conduct at paragraph 22J. So taken together and ignoring entirely what issues of contract arise, we say the provisions of the codes present a number of obvious difficulties in this case. And so the first and the obvious one is in relation to the claimant's duty of confidentiality, because assuming there's no court order, which there isn't, the language is clear in prohibiting disclosure of information unless it has been authorized by the client or its authorized agent. And on the facts that we say are not in dispute, and that for that reason we haven't gone to during the course of these oral submissions, the acute issue here is we've got two adverse parties, each of whom purport to be the authorized agent of the first defendant, giving conflicting instructions on how the claimant should act. As I say, they're not both correct, and until the UAE claims have been resolved, it's impossible for the claimant to know whose instructions are authorized and whose are not. As I say, we don't take a position on the outcome of those claims. It may well be relevant to your considerations that there is a prima facie issue in the UAE courts that needs to be determined one way or the other, but that's not an issue for this court. The only thing that's relevant, the only relevant fact on the Part 8 claim is that the dispute exists and that it's ongoing. And we say that clearly that issue is a substantive one that's going to need to be dealt with by the UAE courts. We obviously have the questions over the 2015 power of attorney used to effect the transaction. We've got questions over whether it was cancelled or not. We don't need to get into those. We don't need to prejudge any of that. The question is whether the claimant has reasonable grounds giving rise to material uncertainty that the instructions it's received have been properly authorized by the first defendant. And if that sort of reasonable doubt exists, what we say is the correct position in accordance with the codes that we've looked at is that the claimant is entitled to wait for the outcome of the UAE claims before potentially disclosing information which otherwise might put it in a position in breach of its confidentiality obligations to Grand Valley. So in effect, unless and until those UAE claims have been resolved, it will be impossible to verify whether the fourth defendant's request for disclosure has been authorised or whether the fifth defendant's instruction not to disclose has been authorised by Grand Valley. So what we therefore seek is the declaration of that entitlement to refrain from acting on the defendant's instructions, at least until that such time as the UAE claims have been determined, or the question of the true ownership and management of Grand Valley has been dealt with. And I think, as I said at the outset, this is very much premised in provisions of DIFC law. That does not mean that it's the only source
I don't mean to cut you short, Mr. Doherty, but I have all of those points. What would really help me is if you now took me to the authorities that you rely on to show that I can exercise a power to make a declaration where there isn't yet a claim, but the possibility of a claim against your client. The factual background I've got.
Yes, perfect. Thank you. Yes, I'm happy to address that. I suppose the way I'll tackle that is to address what I think are the two distinct issues, because there's the issue taken by my learned friend about Part 8 being improperly used. And then I think there's another layer beyond that, which is regardless of what the specific procedure is, what the court's power is when it comes to making an order for a declaration. I'll deal with the Part 8 point very briefly, because we consider that the criticism about the use of the Part 8 procedure is misconceived, where the central issues that are actually relevant to the Part 8, as distinct from whatever factual issues are relevant to the UAE claims, but those central issues for this case are not in dispute. So there's no dispute as to the fact of the execution of the share sale agreement and the addendum, nor is there a dispute that it was executed by Mohammed Al-Sari, the second defendant, using the 2015 power of attorney.
I'm going to cut you short again, because the only relevant facts, as far as I'm concerned, are that your clients are receiving conflicting instructions.
Yes.
The rest of it,
I'll go past that, because I think we may well be on the same page. I just wanted to address those particular criticisms if I needed to.
Unless I'm persuaded otherwise, that's a black cat in the dark that isn't there on this issue.
Okay, thank you. I'm grateful for that judicial indication. So we say for those reasons, Part 8 is clearly appropriate, no substantial dispute of fact. When it comes to the court's discretion to order declaratory relief, the first authority I'd take you to is Financial Services Authority in Rourke. That's F33.
F33. All right. Bear with me a second. Yep.
And really, this is an authority about when the court can make declarations. So I'm looking at the extract at the bottom of the page. It refers to, in that case, of course, provisions of the CPR, but it says the court may make binding declarations whether or not any other remedy is claimed.
Yeah.
And it goes on to analyse that, saying, accordingly, as far as the CPR is concerned, the power to make declarations appears to be unfettered. As between the parties in the section, it seems to me that the court can grant a declaration as to their rights, which is what we would say we're asking for here, or to the existence of facts, or as to a principle of law, which again, what we would say is what we're asking for here, where those rights, facts, or principles have been established to the court's satisfaction. The court should not, however, grant any declarations merely because the rights, facts, or principles have been established and one party asks for the declaration. The court has to consider whether in all the circumstances it's appropriate to make the order. I'll come on to that part, but I suppose first of all, it is an expressly unfettered discretion. It can touch on the existence of facts. It can touch on declarations of legal rights and principles of law. And the only question for the court, or the broader question for the court, is it appropriate in the circumstances of this case to make an order? And some of the relevant factors are then set out if we get over the page. In the center of the page, there's reference to two authorities and then a conclusion below that, beginning, it seems to me,
Yes, I've got that.
that when considering whether to grant a declaration or not, the court should take into account justice to the claimant, justice to the defendant, whether the declaration would serve a useful purpose, whether there are any other special reasons why or why not the court should grant the declaration. So it's hardly prescriptive, but one can see that the court will be getting into the territory of it being appropriate to make that sort of a declaration where it's useful, or more broadly, where it's just for that sort of order to be made. And I'll come back to this, but we would say that that includes a scenario where a party is facing substantial legal claims from multiple parties, where it's in a position of not being able to act one way or the other without incurring the wrath of one of those parties. That point can be seen if we go to the Russian commercial case. That's at, well, it starts at F1, but the page I'm going to go to is F15.
Yep.
And I made the point earlier, this is a case now which is over 100 years old. So it's not some new or inventive deployment of a principle when the court can grant declarations. In fact, the very sort of set of circumstances we're dealing with a case over 100 years ago, this isn't in the CPR framework, which, as we've already seen, confers on the court a very broad discretion when it comes to declarations, indeed broader than it would have been 100 years ago. But the relevant paragraph here is that it's the first sort of new paragraph on that page, about a quarter of the way down, which even 100 years ago says that for many years it has been accepted practice in cases in the commercial list to hear and determine claims for a declaration of right when a real and not a fictitious or academic question is involved and is in being between two parties, in order that they may know what business course to take without having to run the risk of acting and finding themselves liable in damages when at last the matter is brought before the court. So again, what we would say is that even here in the 1920s, the courts are saying that it is a legitimate use it is a legitimate claim by a commercial party to go before a commercial court and seek a declaration as to right in order to ward off threatened legal action, or to enable it to know what path it should take so that it can chart a course through those murky waters of knowing whether or not litigation might arise and whether it might be putting itself
And you would say,
at substantial risk of damages.
You would say a fortiori, if it's not a commercial party but a professional party that is ultimately regulated by the court, it's an even stronger case to get a declaration.
Precisely.
Okay, I have the point.
And the final case I had intended to refer Your Honour to is the Rolls-Royce case at F74. So this is 2009 Court of Appeal decision. And it's at paragraph 120. Which is at the bottom of F74. And this is another statement of general principle, or the general considerations the court will also take account of. So for the purposes of the present case, I think the principles in cases can be summarized as follows. The power to grant declaratory relief is discretionary. there must in general be a real and present dispute between the parties before a court as to the existence or extent of a legal right between them. However, the claimant does not need to have a present cause of action against the defendant. Each party must in general be affected by the court's determination of the issues. For the fact that the claimant is not a party to the relevant contract in respect of the declaration is not fatal to the application. 5, the court will be prepared to give declaratory relief in respect of a friendly action or where there's an academic question, which we say is probably not relevant in this case. 6, however, the court must be satisfied that all sides.
6 was something that concerned me when I was reading, because what I might call the Abdullah side of the dispute are not before me.
Sorry, Your Honor, could I ask you to repeat the point?
Yes, yes. As I said, that something that struck me when I was doing my pre-reading was that one side of the dispute before the UAE courts is before me, represented by Mr. Whitehead, but the other side, what I call the Abdullah side, is not before me. Does that make a difference in your submission?
I don't consider that it does, because we're not dealing with an instance where we're coming before the court asking for a clarification of a point of law purely because we're interested in it. Clearly, whether the parties are represented or not, the order in relation to the relief sought is going to have an impact on the parties in that it will likely determine what course the claimant charts, and that of course determines whether instructions are going to be complied with now or whether they're going to be complied with at a later date. So whatever way one looks at it, if the order is granted in the terms sought, both of the competing sets of parties before the UAE courts are going to be in the position where they're going to have to resolve that dispute first before they can issue instructions to the claimant demanding that it act. So it's not an academic question. It's a question which relates to legal rights, which are being contested by at least one party and which are going to have a direct effect upon the court making an order.
Okay.
And then the final point is, I think, what one would expect in the application of a broad discretionary test is, assuming all of the other tests are satisfied, is this the most effective way of resolving the issues raised? So based on those principles that we've looked at, we say that this is a case which falls squarely into the territory where declaratory relief would be appropriate. As I say, there's clearly an issue between the parties as to whether or not the claimant is obliged to follow either the fourth defendant's instructions or the fifth defendant's instructions, or indeed whether it's entitled to refrain from acting on those instructions at all. And that is what we would say is a real and present dispute about the existence of legal rights. So that's rights under the TIFC's codes of practice, and where the parties are going to be directly affected in a non-trivial way by the court's decision on those legal questions.
Yep.
It's also a case, we say, which falls pretty neatly into the old Russian commercial territory, where the claimant is pursuing its claim in order to enable it to determine what course it should take, rather than risk acting now and finding themselves liable later for doing so. And not only is it trying to chart that course as a commercial party or as a contractual party, but as a regulated party where there is a broader interest, we would say, in the courts, ensuring that regulated parties like the claimant are acting in accordance with their professional obligations.
Yep.
So it's, in that context, one will also note the fact that both sets of legal notices issued at the behest of, or supposedly at the behest of the first defendant, have threatened not only the firm, but its employees with what's variously described as claims for significant loss, irreversible gross damage, grave damage, which the claimant is potentially being exposed to. And it was for precisely that reason that requests were made to withdraw those legal notices. Those requests weren't acted on. So there was, at the point in time that this claim was initiated, a looming threat of litigation that this party was raised to try and avoid. And because the last thing, in addition to claims for damages that the claimant wanted to be exposed to, was costly, arguably unnecessary, and potentially multi-jurisdictional or at least multi-party litigation. And all of that, of course, is relevant to the question of relative justice between the parties, because the claimant is in a situation where, as we say, they're between a rock and a hard place, but really through no fault of their own, have been put into a position where taking any decision risks litigation, whether or not that decision ultimately turns out to be vindicated following the conclusion of the UAE claims. And so we say that in the interests of justice, the claimant's entitled to seek declaratory relief from the court so that it can determine what action to take.
Yes.
And even more broadly than that, on questions of justice, the claimant considers that the steps it has taken in initiating these proceedings are those that one would expect a conscientious, professional, prudent legal practitioner to take when faced with precisely the scenario we find ourselves in. And we say that the court should assist the claimant in those circumstances by providing the declaratory relief that's sought. So that's why we say that this claim falls within the scope of those authorities on provision of declaratory relief. Why we say it's not only necessary, but it's entirely appropriate in the circumstances of this case for the court to make that sort of order. And I'm conscious that I obviously addressed you on that question in relation to the first issue, which is the confidentiality issue, if I can put it that way. I haven't addressed you on the second limb or the second question on the claim form. I can probably do that pretty briefly because it's not hugely complicated.
Well, let's move on to the second. I mean, I think I have your arguments on the first limb, so let's move on to the second limb.
Okay. If we go to F129, first of all, to finish where we left off in relation to the codes of practice, if we look at both paragraph 8.4 and the commentary that lies underneath it, which says on the termination of a relationship, a lawyer should, subject to his lien for unpaid fees, deliver to the client all papers and property to which the client is entitled. It refers to, in the event a new lawyer undertakes to protect the original lawyer's lien and costs, the original lawyer will not be entitled to exercise his lien. And the commentary says where a lien arises over a client's documents delivered to a lawyer in his professional capacity for costs due and for work performed, such documents can be retained until those costs are paid. The lien does not entitle the lawyer to sell or dispose of the court's property.
Okay.
So really, again, this feeds back into some of the observations I made on questions of jurisdiction, which is that this isn't solely about contractual rights and obligations, but it is part of the broader network of professional obligations and professional codes issued by the DIFC court, which one can see as providing a good justification, a good reason for why we see these sorts of provisions mirrored in standard terms and conditions as well. I can take you to the terms and conditions on top of that. You will have no doubt seen them referred to in my skeleton. If you read them, they're pretty clear, but there are 2 points that arise. It's non-payment gives rise to a specific right to sort of lien over documents, but that there's also a more generalized right to suspend carrying out instructions or services where we've got non-payment. So that's what arises out of clause 7.1, which is a B52 for your note. Now, I don't think that there can be any dispute that the invoices have been provided, because we have all of the documents before Your Honour, which shows that the invoices were issued. There are outstanding invoices amounting to around 3.5 million dirham.
They just say they're queried, and that's
yeah.
Well, that is a matter
one,
that is a matter for the English courts, isn't it?
Yeah, well, I don't know, but I suppose the important point is that it's not an issue here, because we're not bringing a claim seeking payment of sums due. So Your Honour doesn't need to go into it. The simple fact is the invoice has been issued.
I can't.
30 days elapsed.
No, unless both parties opt into the jurisdiction of the English court, of the DIFC courts, or I choose to disregard the exclusive jurisdiction clause for some reason, then then the fees are a matter to be determined in accordance with the express terms of the retainer.
Yes, Your Honour, I don't think that we particularly dissent from that. Like
I think
say,
it would be
there are other
difficult
issues that we would take issue with, on the fact simply that none of these invoices were actually contemporaneously challenged. We see it as an attempt to muddy the waters and make it look like there's a dispute of fact, which we say there simply isn't, or at least not a relevant one on about it. And I think there was one other outstanding point which arose from the witness evidence, which I think has been dealt with, but this related to the question of an instruction not to pay invoices because of the existence of a freezing order in the English courts. But that issue was addressed back in July 2022, when an instruction was made to resume making those payments, because arrangements had been
I don't think any of that is within.
Yes, it's really just
to
counter some of the submissions made on behalf of the fourth defendant. But really, we say it's as simple as that. There is obviously the contractual laying over documents, but there's also the regulatory underpin, which deals with lawyers in the DIFC asserting that laying over documents until fees have been paid. And so it's those provisions combined that we rely on in seeking further, or if necessary, alternative declaratory relief with respect to the rights not to act on the instruction to provide documents. And unless there's anything in particular I can assist Your Honour on in respect of that issue, I don't mean to go into any more detail than that.
Okay.
There was one other argument. I don't know if you wish me to address it now for ease. I'm sure my learned friend will come to it. I think there had been some suggestion that this was really a KYC due diligence issue, and so was a matter for the Legal Affairs Department. I only have very brief submissions on that, which is it's difficult to see where the argument goes, because we would say that that's patently not what this case is about.
Let's see what the argument is, and I might test it before you respond to it. Okay,
that's fine. Unless I can assist you further with any questions that you have. I should say that if I would hope that the position that we set out in jurisdiction is clear, particularly having now gone through the provisions of the codes of practice.
No, that you've clarified a great deal for me, and the timing. Your timing is very good, given my given my interruptions. So I think we're probably fine to get on to Mr. Whitehead's submissions.
Certainly, thank you.
Thank you very much, Mr. Whitehead.
Thank you, Your Honour. I think I'd like to start just by saying that the defendants in this case, and I just want to make clear who I think you're aware, but we act for the first, second, third, fourth defendants only. We don't act for the fifth defendant. So I just want, when I refer to the defendants, Your Honour, I just want to make clear that it's only those 4 defendants.
Look, I understand that basically it's a family dispute, and you're representing Mohammed, and on the other side is Abdullah, and that's yeah, okay. I'm there.
Fine.
Okay.
Yeah. Okay, fine. Okay, good. Yeah. So as my learned friend has explained, the claim arises as a consequence of purported changes to the management and ownership structure of the first defendant. What our case, quite in a very straightforward fashion, is that this is a premature claim. These proceedings, in terms of the Dubai court proceedings, the onshore proceedings, they've still not been determined. So
do you agree then basically that CRS should just do nothing until the onshore? Well, I don't like the word onshore for reasons that I'll explain. But till the non-DIFC proceedings have been.
Yeah, look, Your Honour. I mean, just with respect, that's a matter for CRS. It's not a matter for the DIFC courts. The DIFC courts. There's.
I wasn't asking. That wasn't my question. My question was about your position, not the DIFC court position. Do you agree that CRS really are in a position that they should await the outcome of the proceedings in the non-DIFC courts?
Look, if we were in CRS's position, we would go through an internal procedure which we've not been aware of, Your Honour. We don't know what
you're still ducking my question. Do you agree, yes or no, that CRS essentially should await the outcome of the present proceedings?
Look, our position on that is obviously there is a dispute between the parties in the Dubai court, but as things stand, prima facie, there's a government document which has been issued which confirms that the manager is the 4th defendant. So that is.
But it said that that's been procured by false representations, and that's what's being determined before the DIFC, before the Dubai courts.
So it's for a yes or no answer. It does need to be determined. Our position is that that is an issue which needs to be determined, and that's. I don't think the parties dispute that. I think the parties agree that there are, obviously, it's a matter of fact that there are 5 Dubai court cases, civil and criminal.
So what's wrong with CRS awaiting their outcome?
Well, CRS can await their outcome, but our position, Your Honour, is that they have brought a premature claim here in circumstances where our clients simply threatened. I think the wording my learned friend used in the actual letter, it says all legal actions. So that could be legal actions in the UK. Essentially, the position is a contractual position. The only thing between CRS and the defendants in terms of, from a legal point of view, is letters of engagement. And my learned friend said that putting aside the contractual issue, well, we simply cannot put aside the contractual issue. That is the terms of engagement. That is a retainer agreement which has been entered into between the 2 parties, and we can't simply disregard that. And that's where it comes down to the jurisdiction point, in that this isn't a matter for the DIFC courts. It's not a DIFC court's jurisdiction. So our position simply is that if our client did try to pursue this, there would be no requirement for the DIFC court's involvement. And and I would stress here, if our clients did make a claim, so the defendants did make a claim, they would do so in the English courts. They wouldn't do so in the DIFC courts.
Let me be as frank with you as I was when Mr. Doherty started with what my thinking. And Mr. Doherty may be pleased to know that he's moved me slightly on his submissions from my initial position, because when I saw your legal notice invokes the DIFC court's regulatory jurisdiction over CRS.
Well, if I can take you to that document again,
yes.
Let's just go to that one. Just give me a second.
Yes, of course.
Yeah, so I think it's B155.
Yeah.
So, we're looking for the CRS legal notice. So it's
We're looking,
B164.
yes,
B164, yeah.
164. Thank you very much.
If we look here, you're quite right. It does refer to the DIFC code of best practice. So if we see here under notwithstanding the above,
Yes.
but yeah, so it says first and foremost a DIFC registered entity, but again we stress here it's also an SRA regulated entity, which I'll come to later on. And we have complied with the DIFC court's code of best legal practice. Okay, that's sort of your point, if I'm correct, Your Honour.
No, but this is CRS's
yes, yeah.
document. I just want to have a look at your client's document.
So the only sort of point I just want to stress here though is that they
Here it is. I've got
go
it. I've got it here. It is 15. You were right. I think the first time round. 154155. So notifying notifies parties to submit an application to stay, deliver up copies.
Yeah.
Blah de blah. Failure within 5 days shall take legal action against the notified parties for significant loss. So let go a bit.
I think it just refers to take all or any legal action. It doesn't actually specify where.
Yes.
So if we go to the 5th paragraph, which is on 155, it says under 5th, it says in the case of failure of the notified parties to comply with the foregoing within 5 days from the date of the notice, the notified party shall take legal action. It's very broad. It doesn't specify which jurisdiction.
Legal action in the Emirate of Dubai. So we're not talking about the SRA or England. We're talking about in the Emirate of Dubai.
Your Honour, if I may, sorry, I was just going to jump in to give you the page reference for the document I think that you were referring to, which was B167 and 168, is what you were referring to earlier.
Let's have a look at that as well. Thank you.
Just to clarify, on 155, it doesn't say, it just says in violation of provisions of advocates and legal consultants in the Emirate of Dubai. It doesn't say that it would be in the Emirate of Dubai where they would bring action. It just refers to actual provisions of breaches of law. But
those provisions would be, well, the governing provisions of CRS are the DIFC regulations.
Correct. So yeah. If we go to B164, Your Honour, then as we sort of referred to earlier, it says first this firm is a DFC registered entity, and we have complied with the DFC court's code of best practice. But then it says secondly, we act for Grand Valley pursuant to our letters of engagement, and it refers to each of the letters.
Yes.
Now, in the letters themselves, as we're aware, the jurisdiction clause is the English courts. So it reconfirms that in circumstances where there is a dispute, then that letter of engagement between the parties, or letters of engagement, because there were more than one, would be the contractual document which would govern any dispute. And that's in their responsive letter to the defendants.
Yes, and the reply to that is the document at 167, where your clients then terminate the company's retainer with CRS pursuant to the DIFC court's code of conduct.
I think they refer to various stipulations in the DIFC court's code of conduct. But I mean, look, Your Honour, we don't deny the fact that CRS as lawyers, as myself and other practitioners we are bound by the DIFC code of conduct. I'm bound by the SRA regulations. I'm also bound by the DIFC court's code of conduct. So obviously there's a multiple regulators at work here. I think what we're trying to sort of say is that this is more of a jurisdiction point, in that there's a contractual agreement between the parties which confirms that if there's a dispute, it will be the English courts who would have jurisdiction. And if you'd like, Johan, I can take you to that clause. I think you're aware of the clause already in the letter of engagement.
I've read it all. Yes.
Yeah. Yeah.
Yep.
But I think, look, I mean, the main point, again, just to stress, we do think it's a premature application.
Yes.
We feel like if you know, CRS, you're quite right, they could have just stopped acting or just not acted. And it would be then for our clients to bring a claim in the correct forum, the correct jurisdiction. So that's our position on that. Now, in terms of the part, should I sort of go through my submission? Is there any way you'd like me to address my submissions, or can I just sort of go through them?
No, you take your own course. I may ask you questions as you go through.
No, that's fine. So I think one of the main things to address here is that my learned friend said that and I think this is in the skeleton argument at paragraph 8, which I can take you to. It's H4.
Yeah, I've got it.
I think that one of the main points here is that it says that the central facts giving rise to the Part 8 claim are uncontroversial. Now, and in my learned friend's submissions, he's also said that it relates to multi-layered issues before, when he was addressing his case. Now, our position is that this is simply not the case, that it's not controversial, it's uncontroversial. There's essentially 5 pages of submissions on the background facts, which again, based on what's happened earlier, I don't wish to sort of go through all the relevant details on that unless you'd like me to, but there's then 3 pages of submissions on justifying why this is a Part 8 claim. Now, Part 8, as you're aware, Your Honour, it's only in circumstances where there's not a dispute of fact. Now, our client's position is that there is, and you know, there's 5 UAE civil and criminal claims in the present.
But they're irrelevant. The only relevant fact for me is that CRS is receiving conflicting instructions from 2 different factions who say that they're in control of its client. Everything else is irrelevant, isn't it?
I think from their perspective, that's right. Yeah, absolutely. But I think from our client's perspective, as we alluded to earlier, it's a jurisdiction point in that we would say that in circumstances where the issues are at hand, the DFC courts don't have jurisdiction to make a determination on this.
That's a different point on the suitability of Part 8.
Correct. But I think in terms of Part 8, we would just say that Part 8 is a procedure. We would essentially say Part 8 is a procedure which is used where there's not any controversy, but there is a controversy in this case.
Which is what?
Well, which is whether firstly, that there's other UAE civil and criminal claims at hand. And also
there's no controversy that there are other civil and criminal claims. I mean, I think no issue of fact that they exist.
So I think there's multi-layered issues at hand here, which the parties need to be aware, which the parties are aware of.
Like what?
Well, essentially, we've got a situation where CRS don't know whether they should actually go with the client instructions or not. So they in terms of they don't.
But that's not an issue. That's not an issue of fact.
I think the main sort of point on the Part 8 claim is that they just don't know, what they should do. But our argument would be that this is an incorrect forum because it's been made prematurely. Because
well, you said it's premature a few times, so I have that point.
Yeah. So yeah, I think again, I think Yeah, okay, fine. So I'll move on. Again, if I can take you to what the sort of the claimant's duties towards the first defendant are. So
Yes.
obviously the claimant, as we're aware, it's an international law firm in this region, but also worldwide. So it does have certain duties and obligations to ensure that they carry out customer due diligence and, you know, to ensure necessary documents are in order. In our submission, we basically say that as I've said, they're bound by the SRA code of conduct, but also the DIFC code of conduct. So there's two regulators at play here. And in anything we do as practitioners, as you're aware, we need to make sure that we are compliant with both. But there's also, as we're all aware, because we all have to do CLPD, the Government of Dubai Legal Affairs Department. So this is another aspect which we would say whether the claimant has actually looked at their guidance and complied with that. Now, turning to the two key issues, I think in terms of the key issues which my learned friends addressed here is the first one, whether having regard to the legal and regulatory obligations and the terms of its engagement with the first defendant, if it is permitted to comply with the instructions. So I'd like to do with that one first. So I'd like to consider the change of ownership of the first defendant is the first issue. So the position in relation to the ownership of the management of the first defendant was communicated to the claimant by way of a stamped letter, which was dated 25th of August. I can take you to that letter, which is B145. So this is a letter to Ms. Sheffield, which confirms that you know that they have the authority to act. So what our position is that it is irrelevant for the claimant to raise an issue regarding ownership and management position of the first defendant in circumstances where the current trade license of the first defendant is a government issued document and it was communicated. And what our instructions are, Your Honour, is that the change of ownership of the first defendant were carried out in accordance with the relevant UAE laws and were reflected in the first defendant's trade license, which again is a government document. Yeah, okay.
That's
fine.
the issue for the Dubai courts.
Okay, fine. I'll move on from this because I think that you're quite right. It's a matter for the Dubai courts to determine. So I mean, just coming back to the Part 8 claim, what we would say here is that we question the relevancy of the Part 8 claim, and we do so for a number of reasons. We say that the parties to the Part 8 claim and the parties that have been referred to in the UAE onshore port disputes are in fact different. We would say that as we said, obviously the UAE onshore port disputes are heard in a different jurisdiction outside the DFC courts, and importantly, no determination has been made in respect of those disputes. So to come back to your first question, that is an issue in this case, and that those matters need to be determined. So we don't dispute that. I think that is agreed between the parties. And also the fact that the claimant's representatives have actually confirmed that the claimant has asked the DFC courts to resolve or opine on the issues in the UAE onshore port disputes. But as you quite rightly say, Your Honour, that isn't a matter for the DFC courts. What we are perhaps struggling with slightly here is why the claimant has in fact gone to the DFC courts for this. Again, you know, we've mentioned here that the claimant is an international law firm. It knows what my learned friend obviously took us through the DFC code of conduct. He didn't take us through the SRA code of conduct, which perhaps he probably should have. But the point here is that we're all aware as practitioners of our duties as lawyers. So the fact that is that should the DIFC court just be reconfirming what is already in a mandatory code of conduct, it's already there for all to see. We're aware, we have training on that, and we're all qualified in those respective jurisdictions. I'll just move on now to I think perhaps separately, with something I would like to just address is a small point, but I think it does need to be considered here. Is that the claimant's representatives have contended that the instructions which were issued by Majid Al-Sari to the claimant were issued pursuant to a power of attorney, asserting that he had authority to act. So here, what our position is, any instructions that were given were actually invalid on the basis of the contents of the power of attorney. But is that something you want me to sort of address, or?
No, that has to be for the Dubai courts, doesn't it? Whether or not, because that depends upon whether or not Abdullah was the manager of the company, and whether he in turn could give a power of attorney to his other son, Majid, to act on his behalf. So it goes to the core issue as to whether Mohammed or Abdullah are in control of Grand Valley, and whether Mr. Sorry, I've forgotten his name.
Yeah.
He wrote the letter. Sorry, it should be just in front of me. I forgot. I hope you just forgive me. Mr. Arabiat. Yes, forgive me for forgetting his name. So the question is whether Mr. Arabiat was the manager, or whether Mr. Abdullah was the manager, and then whether Mr. Abdullah then could by power of attorney delegate his powers to his son Majid. So that's an issue that goes to the heart of the matter between the parties, doesn't it?
Yes, exactly. Yeah, exactly. So that submission on that is that Mr. Majid did not have authority to sign the engagement.
Okay, but that's not something I can decide.
Because I think I accept that, but I think what we're saying.
But I mean, the point that you have made that does interest me, and I said at the outset that you just made, it is, and it really goes into my discretion as to whether or not to grant declaratory relief. Why should the DIFC court be effectively confirming something which one can glean from a reading of the rules themselves? And then it's a matter for the party to decide how to act on the basis of that reading. And if that gives rise to a claim, that gives rise to a claim. The answer to that Mr. Doherty gives is, well, it's perfectly legitimate that if there is a real prospect of and not a fanciful or theoretical or academic prospect of a claim, if a party acts in one way or the other, then it's legitimate for that party, before the claim is made, to get the guidance of the court as to how it should act. And he says a fortiori, when the court is actually the regulatory authority of a professional party, and not just simply giving an opinion in relation to a commercial transaction. So I think what you've got to address me on is in development to the point you're making. Is it right that I should get involved in this, as it were, as a matter of discretion, or is it really up to CRS? You would say, you say they're a seasoned law firm. It's up to CRS to make its own decision and then take the consequences of that.
Right. I think the what we would say on that, Your Honour, is that if we sort of play this through step by step in a sort of a flowchart perspective, my learned friend said that there's no dispute regarding the invoices. So there is.
No, there is a dispute. I don't
Yeah.
think I don't think he says there's no dispute about the invoices. I think it's clear from his own evidence that there's a dispute about.
Fine. So okay, fine. If the invoice is a dispute, as you quite rightly said earlier, then the correct forum to go to is the English courts. Now, if and then after that, if we logically move forward from there as the next step, then once that dispute has been resolved in the English courts, then only then will this Leon issue be resolved. So the logical forum is to go to the English courts, and that's crystallized and clear from the letter of engagements between the parties. It seems quite bizarre why the DIFC courts have become embroiled in this dispute in those circumstances. I think the only sort of glimmer, if you like, of how the DIFC courts have become involved is circumstances where CRS have an office in the DIFC, and also their practitioners are also bound by a code of conduct, that being the DIFC code of conduct. But they do also have English offices and are also bound by the SRA. So our position is that this is quite clearly a case where the English court should have jurisdiction. In terms of the issues, it makes sense because the outstanding issue at the moment from our client's perspective, well, from CRS's perspective, that they're not being paid their fees. And only really then, until that issue's been determined, can the Leon issue be determined. Yeah. I think the only other point we'd just like to just perhaps embellish on that is the fact that our client, despite asking for these invoices, and again, that's indicative in the correspondence which my learned friend took us through, is that they have been asking for itemized invoices. Now, in Mrs. Sheffield's witness statement at paragraph 55, and if I can take you to that, which is at B19 of case lines, in paragraph 55, it says, Mr. Sheffield says, Mr. Al-Aribat has requested copies of this firm's outstanding invoices. Copies of the above listed invoices will be, and I'll stress those words, provided to Mr. in due course. Again, stress those invoices. So they've not been provided yet. That's a second witness statement. Sorry, first witness statement.
Isn't there a problem? Again, this is something that occurred to me when I was reading, because it's an issue that often arises in relation to claims of privilege. Isn't there a problem that the narrative to proper invoices might contain information which is confidential, and therefore actually until it's decided that your clients are the true controllers of Gulf Valley, then CRS would risk breaching their obligations of confidentiality to the other people who are claiming to be the controllers of the company.
Perhaps, but I think what our argument would be on that would be that the narrative can be redacted, and also.
But then your client's going to say, if I've got a redacted narrative, how can I challenge these invoices? I don't know what they've been doing.
Yeah, I think what we would say presumably is that if there's anything which was privileged, I mean, you would still be able to determine the general.
Well, I wasn't saying, and I was only saying privilege on the basis that that's usually the context in which this argument arises. It's slightly different here. The question is rather of confidentiality. Yes.
Yeah. I see your point. But I think there would have to be a pragmatic approach to that point. And again, I think the thrust of the invoices be that with certain words redacted might be the way forward there. But again, we would say it logically follows that if the DOC court was the correct forum from which to bring a claim in circumstances where the invoices amounts are disputed, the correct procedure. I mean, look, we would even say here that if you know, if CRS were to bring a claim in the DOC courts, then it shouldn't be brought. But in any event, not under Part 8, but under Part 7. But we would say it's the English courts which need to deal with that.
I see
Okay,
that.
so I think the other point we would raise here, I'd just like to raise a different issue, because I think there was talk before of there being a conduct issue, and what we'd say is, obviously, in terms of a disciplinary complaint, that it's very distinct. So as we're aware, the Legal Affairs Department would address any disciplinary complaint, whereas the courts would address any civil issue, which would be non-payment of the invoices. So what our position is there, again, is to say that there is existing regulations in terms of what to do in circumstances where you are receiving conflicting instructions. It's quite clear from relevant codes of conduct on what to do. And this is precisely the circumstances here. We would say that the CRS, having gone through my learned friend went through the correspondence, but under no circumstance do they actually list what their obligations are. They don't go into detail in terms of what provisions of the code of conduct have been, they are under scrutiny on. It's just a very general, vague, broad brush. We are under a code of conduct. There's no, from our client's perspective, obviously as a lay client, and also what we'd have to stress here is that they weren't, obviously we as DOC court lawyers, the common law qualified lawyers, in terms of the SRA and DOC code of conduct, we weren't involved at that stage. Perhaps had we been involved, then the client may have taken a different responsive approach in terms of how they would refer to various provisions in response. But we would say there that it would be incumbent on a law firm, international law firm, to actually specify which provisions of the DOC code of conduct are being considered and need to be addressed. So only then can our client really understand what the issues CRS perhaps are having difficulty with. So I think it's unfair. I think in terms of, because obviously my learned friend then went through the case law, and I think in one of the cases, I would like to just address some of those cases now, if I may.
Yes, of course.
Yeah. So if I take you to, I think it's F74. So it might be F. So it's F120, I believe. F120. It says in one of the cases. Oh, sorry. You mentioned justice to the defendants. It might be F74. Sorry, just bear with me, Your Honour. Just trying to find the reference. We can perhaps come back to this, but essentially in one of the cases, which I'll ask our team to look at now, it also
so it's an F34. It's the road case.
Thank you. F34. Okay, fine. Yes, here. Thank you. Yeah, appreciate that. So here, yes, it says here, it seems to me that when considering whether to grant a declaration or not, the court should take into account justice to the claimant, also justice to the defendant. So this is a point we want to stress here. Would there be justice to the defendant if a declaration was made? Now, our argument here is quite simple, that it would not, in circumstances where it's been brought in the wrong jurisdiction, and also from a law firm, an international law firm like CRS, to claim the amount of costs for this hearing, which they have.
Well, we'll come to costs and of this hearing in due course.
Yeah. So we would say it's not in compliance with the overriding objective, and it's not proportionate to bring such an application. It's premature, and the legislation is already in place quite clearly for practitioners to know what to do in those situations, and it's not for the DIFC courts with respect to hold their hand to say we want you to do this. The CRS International Law Firm, they have partners and experienced practitioners which should be aware of what to do in such a situation. Okay. Again, I'd like to then move on to now the SRA's code of conduct. So under Rule 4, and I'll take you to.
I've looked at that.
You've seen, yeah.
Yeah.
Okay. Because that, as you're aware, it specifically says that, yeah, you've considered that, so I won't go through that again.
Can I say that I was attracted by the position, particularly in relation to SRA Rule 4.1,
Yeah.
that basically CRS might just as well resign. But thinking about it a little further, and I'd be grateful for your submissions on this, they may well take the view that they'd be doing neither party a service by doing that, because they've been, I don't know how long they've been involved in these particular arbitrations and how much, as it were, corporate knowledge the law firm possesses of the issues in the arbitrations. These are very, I know the Suntech litigation goes back to 2017 in this court. And so it struck me that CRS may well take the position that whichever side comes out on top in the Dubai courts, they should have the benefit of CRS's knowledge and experience of this long-standing piece of litigation, and that so it would be wrong for them just simply to walk away from it. What do you say to that?
Yeah, I think that's absolutely valid. But again, I think it's been done the wrong way with respect. I think our submission is that, and I'll take, if I can, just take it to B54, sorry, B57.
Yes.
On case lines, and this is, and I know we're all aware of this, but this is the governing law and jurisdiction clause, which says unless our letter of engagement states otherwise, then it just doesn't state otherwise. It's quite clear that if there's an issue such as this, English law will be will prevail, and it will be governed by the jurisdiction of the courts of England. So instead of all this effort which has gone to try and seek some comfort from the DIFC courts under a Part 8 claim, which again I know we'll address costs later, but there's an exorbitant amount of costs requested for this, then instead perhaps the correct procedure would have been to go to the English courts, get this invoice issue resolved, and then once that invoice issue is resolved, our client can get the documents, which will then address your point in terms of allowing perhaps another firm to get all the information so that they can act in the best interest of the client. Now, if, for example, they get this declaration today, CRS, what does that do? It just creates a pause. It's almost like pausing the television. It doesn't really. It just gives them some comfort. It doesn't.
The
really...
problem that, forgive me, Mr. White, the problem with that argument is this, that even if we go to, well, not even if necessarily go to England, if your clients just said, okay, we're going to pay every penny that CRS are asking for, now we'll have the documents, CRS is still in the same position of saying, are we going to breach our duties of confidentiality to the other side in your dispute over the ownership of the company? And they're still stuck piggy in the middle, even irrespective of the fee issue, which is why I think Mr. Doherty really rather played down the fee issue and said, well, it's just another reason for not handing over the documents, but it's very much peripheral to his main point. His main point is that CRS are bringing these proceedings so that they understand how they should act in accordance with the DIFC Code of Conduct, which has been invoked against them in relation to receiving the conflicting instructions from the two sides in the control dispute.
Which I do understand, but I think are we not further forward, or not more further forward by if it was to go to the English courts rather than to the DIFC courts, because at least the issues are narrowed between the parties. I appreciate there is still this confidentiality issue, but again, that's not for the DIFC courts, the English courts to deal with. That's for the UAE courts to deal with, and only.
Well, but their duties of confidentiality arise under the mandatory code of conduct.
Well, and the SRA code of conduct.
Mm.
So our argument,
and I can speak. I can make a declaration as to their obligations under the DIFC code of conduct. Can't I?
What, with respect, Your Honour, why do you need to? Because it's already in the DIFC code of conduct.
Well, that's the point.
Yeah. So, we'd just like to focus on. I think we probably. I mean, we've touched on it, but perhaps we need to, because we dealt with the first issue. But perhaps we need to consider the second issue as well, which is the Leon point, which is the claimant has referred to C's regulatory obligations under the terms of engagement, whether it's permitted to exercise a Leon over the defendant's documents. Again,
well, my reading of I think it's Article 8 that we're looking at, is that it's essentially giving guidance where there is a contractual lien. So it doesn't say that there is one in every single case. What it says is, if there is a lien, this is how it operates.
Yes. Yeah. Yeah. So, well, I think our argument on that. So I didn't quite understand your point, Your Honour. If perhaps you could just
what I'm saying is that that provision, if you want to look at it,
Yeah.
my reading of it is it's explanatory in the sense that it applies where there is a contractual lien. What it doesn't do is say that there is a contractual lien.
Yeah, I accept your point. Yeah, correct. Yes.
That depends on the terms of the retainer between the lawyer and his client.
Correct. Yeah. Yeah.
Sorry, I used the word his, I shouldn't.
Yeah. That's
the lawyer and their client, yes.
Yeah. So I think you know, the I think the point we would stress here is that there are still issues to be resolved between the parties at this stage, which can be resolved. And again, we would very much question both on jurisdiction and use of Part 8 in those circumstances. I'm just sorry, just if you give me a second, Your Honour.
Yes, of course.
Yeah, I think my learned friend made reference to criminal sanctions, or you know, the fact that there has been referred to. But again, we would say that, you know, the DFC courts are not in a position to determine those.
No. Well, I think he
yeah.
accepted that.
Yes. Well, I think perhaps I may have mentioned this before, but my learned friend did mention the fact that you know, ignoring what issues of contracts arise, but I think we just simply cannot do that for the reasons I've already given. And I just think as we went to the case earlier where it referred to justice to the defendant, I don't think it would serve justice to the defendant to make the declaration. I think the idea of the declaration is if there's justice to both the parties. So, but if in all the circumstances, whether or not there would be justice served to all the parties, and I think in this instance that there wouldn't be that because there is already mandatory regulatory provisions which explain what parties need to do in circumstances such as this. So it just seems that requesting the DIFC court's consent is slight. Again, I'll come back to the same word. It's slightly premature. If anything, would it not be for our client to make the claim? Rather than CRS if they had some discomfort in this. And I think we've all seen as seasoned practitioners that there's various letters of claim and legal letters which are sent, but that doesn't necessarily mean that those will be acted upon. You know, in terms of whether there was a serious threat of litigation. You know, there was no court issued proceedings. There was nothing really which would warrant such a drastic step to make this such a detailed Part 8 claim in those circumstances. You know, there have been correspondence between the parties. How many times have we been in a position where you know, for example, you are on a customer service call to a retailer and someone says, I'm going to make a claim. Does that warrant making a Part 8 claim? Does a message, you know, text messages saying I will bring legal action then warrant a Part 8 claim? I think the concern we have is that if this was successful and CRS did get this declaration, then there would be a potential opening of the floodgates aspects in that it would lead to perhaps numerous claims where people would just seek comfort from either the DOC courts or other court systems just so that they protect themselves. I disagree with my learned friend in terms of this threat of action against individuals. That doesn't make sense in circumstances where each of the individual lawyers and practitioners would be covered by the professional negligence insurance of the firm itself. So I don't think that's merited in terms of an argument. I think it would be simply the professional indemnity insurers picking up the tab in circumstances where there's a negligence claim, as we're all aware. So I do have difficulty with I appreciate there was some heated correspondence between the parties, which we've already gone through at this time, and perhaps still there is, but I think, you know, in reality, was any settlement, were any telephone calls had? We just don't know. We don't have the file. We don't have the file notes. You know, was a meeting held with the client? What were CRS's internal procedures at this time? Presumably, they've got an internal procedure in terms of dealing with client complaints. We're not aware of what those internal procedures are and whether they were actioned. You know, obviously, as an international firm, presumably they've got a central office either in Dubai or in another office in a different jurisdiction. So I don't mean to labour the point, but my argument is that, you know, there weren't clear. I think in a lot of the letters, as we've said, it refers to all legal actions, which is very generic, very broad, and it's quite a throwaway comment in a lot of respects in terms of obviously what legal actions they are, but it's almost a reservation of rights point. We would argue that they were keeping all options open, as it were. So that's my submission on that. Yeah.
Thank you. Are
So-
those all of your submissions?
Yeah, I think unless there's anything more, then by way of submission, then that's any questions. I'm happy to address any questions. Yeah.
No, I interrupted you enough during your submissions with my questions. Thank you very much indeed. Right. Okay, Mr. Doherty, you have the opportunity to respond to that.
Yes, thank you, Your Honour. I will try and be concise. Picking up on one of the points raised relatively recently, as well as at the outset, one of the things that's being said is you can't put aside the contractual issue. Now, we say you don't need to do that, but absolutely, if the court did find that it needs to, you can, because we are primarily relying here on regulatory provisions, not on provisions arising out of the terms of engagement. And those are DIFC codes for DIFC licensed entities and DIFC legal practitioners. And as I said during the course of my submissions, you can grant the relief that we're seeking based on those grounds alone before one even looks at the contract. And so that's why we say, even putting to one side the contractual issue, you have the power to make the declaration that's sought. We can see that even more clearly if one actually considers the term in which the jurisdiction clause my learned friend relies upon is considered. I don't necessarily need to take you to it. It's a B57. If you wish to look at it, I'm sure you have already.
No, I've got it well in mind. Thank you.
But what it says is our agreement with you will be governed by English law and will be subject to the exclusive jurisdiction of the courts of England. It doesn't say any dispute between us will be subject to the exclusive jurisdiction of the courts of England. So even on my learned friend's best case, the only issues in which the UK courts could have jurisdiction is on the contractual issues. The UK courts, by contrast, cannot have any jurisdiction over the primary way in which this party claim was put, which is on the basis of DIFC law and DIFC mandatory codes of practice. So even if one were to take the view that the contractual issues are subject to an exclusive jurisdiction clause, there are two approaches, each of which we say leads to the same outcome, which is that the court can make the declaration sought. One, because it proceeds on the basis of the codes only and ignores the contract, or two, where one takes the Carafi-Orion view, which is that an exclusive jurisdiction clause can be displaced where there are strong reasons to do so. For example, in this case, as in Carafi, where you'd end up having fragmented proceedings where issues are partitioned off, some are dealt with in one court, some are dealt with in another, and you have a risk of different approaches, different decisions, and so on. So the point really is that either way we get there. There's a second layer to that, which is relevant not only to the question of jurisdiction, but also to the exercise of the court's discretion and the desirability of ordering the relief sought, which is that this isn't only a contemplated claim against the claimant, the law firm, but what we have is repeated instances, including formal legal notices, being issued against individual lawyers and employees of the firm. Now, they're subject, as lawyers practicing in the DFC, to those codes. They can face sanctions under those codes. Those individual lawyers have to act in accordance with those codes and those obligations in relation to confidentiality. But those individuals who've been threatened with those actions don't have any contract with the first defendant. So it's yet another view as to why the court properly has jurisdiction in this case. It's also relevant to the court's discretion and why it's desirable for the court to make a declaration in the terms sought, because on one view, why do we require a declaration? Well, if you don't, you expose those employees to litigation that's unnecessary and avoidable. I think my learned friend made a somewhat dismissive point about those not being real or genuine threats. With the greatest respect, that's an extraordinary submissions where we have 3 separate letters and formal legal notices issued by legal representatives appointed.
I'm going to take those letters at face value.
Yes, thank you. So, yes, and of course they say that we'll initiate action. So that's why the court ought to exercise discretion, or another reason why the court ought to exercise discretion here. It potentially leads on to the discussion which has cropped up a couple of times, which is, these are a question of codes. Should the DIFC court interfere? Like I say, that's one reason why the court should interfere. But the question itself, I think, slightly focuses on the wrong issue. The claimant as a law firm is, of course, aware of its professional obligations. This is really about an applied exercise of those obligations. So it's not about, does a confidentiality obligation exist? Of course it does. The question here, and the issue here really, is whether or not the claimant should act, or whether it can act, where the question of authorization of instructions being provided is an issue, and whether that gives rise to a confidentiality problem. And even the most seasoned international law firm can't second guess the resolution of that dispute and how the UAE courts are going to resolve the question of authority. And really that's the nub of the problem, because the claimant is aware that these obligations exist. It's just in a situation where it can't positively act until the authority issue has been decided, because otherwise it might place itself in breach of its obligations. And as I say, that's an issue which this court has an interest in dealing with, not only from the firm's perspective, but as I say, because we have this particularly acute issue where the claimant's employees are also being threatened with that litigation. Those were the primary points I had in response. I did have a very brief observation on a couple of smaller issues. The first is this idea of justice to the defendant being a relevant consideration. That's quite right. It's also, at best, a pretty neutral point, because what we have here is a set of defendants who have competing interests. So when one looks at justice to the defendant, it's not only justice to the Mohammed parties, it's justice to the Abdullah parties. And I'm sure that one would say that justice to one is injustice to the others. So those considerations, we would say, cancel each other out, in the court making any order on that basis. There were some points raised about itemized invoices. I don't know if you need me to go through those.
No, I don't.
I was entirely correct.
No, I don't. And
Okay.
Unless there's anything that is not a repetition of what we've heard before, I'd like to use the remaining 20 minutes we have on the issue of costs.
Yes.
Is there anything else that really isn't saying he's not answered what I've said?
No, I don't think so, unless there's any particular issue that you feel you need to hear from me from, including if you feel you need to hear from me in writing on, as I say, questions on jurisdiction or Karafi or anything like that. But
no, I mean, I've got the arguments on that. So if there's nothing new, I'm going to move on to costs. Okay.
Yes. Okay.
Okay, and I'll give you first. I'll give you first submission on that. So I actually got what I think is the third statement of costs from your clients. There was one statement that originally didn't have hourly rates in it. I think then that was corrected, and then hourly rates were put in, and then we got another one this morning that didn't have hourly rates again.
Yes, I can see that they do it. So I think I wonder if it's a potential issue with the submission platform, because I note that there's also a rates. So when it comes to the fee earner section of both statements,
well,
the rates read zero.
Yes, I did have a case earlier in the week where somebody said they had a problem filing their statements of costs, but I can. What is the difference between, leaving aside the hourly rates, what is the difference between version 3 and version 2?
I might have to take instructions on that, because I only have one version. So I'm not
Okay.
clear what it is. The version I have is a grand total of 322,426.83. The one,
Okay, I've got that
yes,
as the
okay.
bottom
The
line.
one from this morning includes the disbursements. So I think that an earlier version might not have included the disbursements.
Okay.
So principally court fees.
Okay. So, but there are hourly rates in version 2, so we know what.
Yes, and
what
we
they
can,
are.
well, as we go down, after you look at the headline hourly rates under fee earners section, when you go to the actual cost, you do see the rate has been populated there.
Yes.
So you
Yes,
have
that's right.
Sheffield 2840. So I think in
Yes.
both sets of submissions we can
It's
see
only
what the
on
rates
it's
are.
only on the attendance section that the hourly rates are missing. I see that. Okay, so at least we know what how things. I'm sorry, it's not the attendance. It's under the fee earner section, but under the actual costs themselves, the hourly rates are there. Okay, right. So what do you say first of all about costs then in terms of success, full or partial, and who pays?
Yes. So I think the core of the submission really is that the claimant has ended up, through no fault of its own, in a somewhat unfortunate situation of, we say, having to bring these proceedings to ward off potentially costly, lengthy, threatened litigation by defendants on both sides of the dispute. Where those costs have been incurred, if the order is made in the terms sought, we would say that those costs ought to fall payable. We appreciate that there are potentially issues of carving through how those costs ought to be payable, given that there are 5 defendants who have been added in order to be bound by the outcome of proceedings. But I think given where we are, the claimant's position is that a cost order, if made, is probably most properly made in respect of the first defendant.
Well, I was
And there are a
wondering.
few reasons for that.
Yes, I mean, I
Yes.
see that, and I actually wondered whether your clients might not just bill the first defendant for these costs full stop, and then leave it for it to be decided when we know the outcome as to whether it was an appropriate matter to bill them. So whoever
can
is
see
in
that pragmatically, I think it
control of
does
the
give rise. Sorry.
So I was going to say, whoever then is in control of the company, the company bears the costs of sorting out what needed to be done, because the company is your client.
I can see that. What I can also see as being the problem in that approach, whilst pragmatic, is a scenario in which whoever ends up succeeding comes back and says, well, you should have just followed my instructions. Sorry, whoever succeeds in the underlying litigation,
I see
says,
that.
you should have followed my instructions in the first place. And I think that then puts the claimant in a somewhat difficult scenario. We don't know what the outcome is going to be.
Yes.
But
each party says that the other one's to blame. I see that.
Yes. I think in terms of rationale behind making the order with respect to the first defendant, of course, is that what we have is from its sort of 2 competing managers, Mr. Al Arabiat, the 4th defendant, writing letters in Grand Valley letterheads stating that he's acting for and on behalf of Grand Valley. And similarly, the 5th defendant issuing his notice saying that it is done in his capacity as manager of Grand Valley. And so that one might take the view that both sets of instructions have independently put the claimant in the situation of needing to raise these proceedings, and that the proper
But the
order would be
reality,
to view these instructions.
Mr. Doherty, the reality is that the essential dispute is between Mohammed al-Sari and his father. And ultimately, aren't they the 2 sides that to this dispute?
Yes, it may well be. I think there are a couple of conceptual difficulties with viewing it in that context, though, because we don't know what the outcome is going to be in the local courts. We don't want to obviously prejudice the outcome, and it's difficult to criticise a party for asserting its right to issue instructions when its right to issue instructions is not going to be resolved until a future date. What one could envisage probably happening in circumstances where the order is made as against the company, Grand Valley, is that Grand Valley would be in a position of being able to seek to recover its lost costs in this claim as against whoever the losing party was in
How do
UAE
they do
claims.
that? How does the company do that?
It would presumably be a claim for damages. So the damages that have arisen as a
Damages
consequence
for
of
what? What cause of action would the company have for the costs in these proceedings against the shareholders?
No, so in this scenario, one would assume it wouldn't be against the shareholders. It would be following the resolution of the UAE claims against the party who it turned out were issuing instructions on behalf of the company without authority to do so. Yes, precisely. So one could, of course, it's going to be a matter for the company to take advice on, but one could see a claim being formulated in those terms and those sums potentially being recoverable as lost to the company in some other form of proceedings. Really, it's a matter for the company. But I suppose the central thrust of
it seems to me to violate the concept of separate corporate identity or personality of the company and its shareholders. This is the shareholders' dispute. The only reason that the company is joined here is it's your client is affected by this. It's a necessary party.
I think that it's difficult to formulate, of course, because I'm not a UAE onshore, if I can put it that way. I know you don't like the term, litigator. So it would be a matter as to how you formulate that claim. But one could see.
I can't see it. I can't
certainly
see one at all.
In UK terms, where you have a third party who holds themselves out wrongly to be acting on behalf of a company that causes that company to take some steps which have incurred a financial loss, what we would have, I guess this is where the sort of reflective loss issue you've alluded to comes in. It wouldn't be a claim by the shareholders against the third party who was the improperly behaving party. It would be a claim by the company for the loss sustained by the company for the costs that it unnecessarily occurred through their actions.
Let's just roll this back a bit. First of all, why should the company bear the cost of these proceedings anyway?
Well, it's of course a matter of the court's discretion, having taken into account the arguments that have been made, whether they're successful or not. So it is a broad discretion. The
company is not one of the parties that is threatening CRS or giving CRS the headache that needs resolving. It's the shareholders. There's an underlying shareholder dispute.
The correspondence that has been issued by the company managers rather than the shareholders.
Those who claim to be managers nominated by the shareholders.
So I suppose the starting point we would suggest is that the appropriate order is where you have those competing claims being made by two parties who are said to represent the company. The reason that the party and proceedings have been initiated in the first place is as a consequence of instructions issued by the company or reportedly on behalf of the company. And if that is the case, the proper cost order ought to be made against the company. And if there is then some residual right of action that accrues to the company as a consequence of some wrongdoing, some kind of tort, some kind of breach of fiduciary duties, something like that, by those managers who were acting without authorization, then that ought to be something that they go off and pursue after the proceedings have concluded. But probably the most prudent course on costs for now is to say that the costs have been occasioned by the company, which is ultimately who is making the threats of litigation and in whose name the litigation would have been raised.
I don't see that, to be frank. I mean, what I see, two sets of shareholders, or who claim to have appointed managers of the company, and those managers or purported managers of the company are the people who are making threats against CRS, not the company itself.
Again, I suppose our position is on the fact that the threats have been issued by Grand Valley, or
well, no, they purport. On your case, they purport by one party to have been issued on behalf of Grand Valley, because one party or the other had no locus standi to make any threat or do anything else on behalf of Grand Valley.
Yes, one can see. I appreciate the problem. I think that given the status of the UAE claims, the primary position that I've has to be that the costs in these proceedings would be properly payable by Grand Valley. I don't think in the alternative
what that ends up, of course, is the innocent party, the innocent group of shareholders or shareholder, is the one then who is affixed with these costs, and the party who was in the wrong, then the company has to find some cause of action, which I can't at the moment imagine, to recover those costs from that party. It doesn't make sense to me.
Yes, I think that's right, Your Honour, because they would then perhaps have to go back to the DIFC courts to seek to recover those costs there.
Well, in my submission, it would be a matter for the company at that point in time to seek advice. My alternative position is, again, given the position that the claimant has been put in and why the proceedings have been brought, it's probably not a case where it's appropriate to make no order on costs. I think in principle, the claimant has incurred costs which ought to be properly recoverable. It may well be that this is a scenario in which costs reserved might be the appropriate order, because further down the line, one will know who the party responsible for necessitating these proceedings is, and that would be on the conclusion of the UAE claims.
That may be some time.
That's why my primary position is that the more desirable outcome is that this is the costs incurred by the first defendant by people who are acting on its behalf, or at least one of whom is acting on its behalf. I think one can take the view that these proceedings would have been necessitated whether we had one legal notice or two legal notices. So in either event, a legal notice has been sent on behalf of the company. There has been the requisite authority to issue that legal notice threatening proceedings, and that the company ought to bear the immediate costs of that. And if it has any rights in relation to that wrongdoing, it's a matter for the company to pick up in due course and seek advice about.
Okay, well, I have your submission. I have your submission on that. Now, well, I'll leave you to reply to Mr. Whitehead on quantum, because I know he's already notified us that he has some submissions to make on the amount of the fees claimed. So I'm not going to come to quantum just yet. So as I said, I'll leave you to reply to that. Is there anything else that you'd like to say on the principle of costs?
I think I've dealt with principle. I'll come back on particular issues with cost.
Mr. Whitehead, and let's as I said, we had the full 3 hours, but I have another thing that I have to deal with. I can give you another 15 minutes or so.
Yeah, Your Honour, I'll keep it as brief as I can. Your Honour, I think the main point that we'd like to make here is that if the claimant did have legitimate concerns, which were justified by reasonable evidence, then why did they not invoke the termination provision in clause 18.1 of their standard terms to terminate the engagements and then enable the defendants to engage new lawyers to assist them with the dispute. Our main concern here is the dispute's sort of growing arms and legs in that it's clear that CRS haven't really understood or known what to do in terms of their with respect with their professional obligations, and as a result they've sort of seen no option but to go to the DIFC courts. But again, as a seasoned law firm, one would expect them to adhere to the mandatory codes and regulations which were already set in stone and in place. If the risk was such which justified termination of the engagement letters, then again the claimants could have written to the defence to allay and justify and explain these concerns with a view to trying to reach an amicable resolution. Instead, what appears to have happened is that there's correspondence which, again, even for me as a practitioner, is quite it's quite confusing in terms of referring to the letters of engagements and the code of conduct, and not being clear to the client and acting in the client's best interest, and again furthering the overriding objective in our view, which to deal with the case in a proportionate manner. And instead it would appear that just unilaterally and in our view unjustifiably issued this Part A claim, which has cost the defendant a lot of time and cost in having to deal with the matter. Again, and I'll stress, you know, the CRS are aware of their professional obligations and duties. If they did have concerns in respect of acting, then they could have allayed these concerns and then could have referred back to their standard terms and conditions. And instead, again, they've asked for the DFC court's assistance. So what are, in terms of coming back to this on our submission on costs, is that essentially CRS have incurred a significant amount of costs compared to what the defendants have incurred. And there was no engagement letter between CRS and CRS in terms of representing themselves in this case. Now, I understand Mr. Doherty has been appointed as instructing counsel, but the brunt of the costs in the statement of costs would appear to be with the respective CRS lawyers. I would like to refer to a case on this. I can give you the case reference. It's Christopher Ian Robinson versus EMW Law LLP, and the citation is 2018 EWHC 1757. Here, I'll read an extract from the case. Apologies, it doesn't appear that I've got the paragraph number, but if I read an extract, it says, where a solicitor has been instructed by a law firm, he was able to recover legal costs for time spent on the matter, provided that the issue was whether it could be shown that the solicitors were instructed before the date of the written retainer. And in this case, as they were already on record, they had clearly been instructed prior to the retainer being signed by the solicitor. It therefore followed that unless the parties could produce written evidence that the solicitor would not be personally liable for the costs prior to the retainer being signed, then it can be presumed that the solicitors were indeed instructed and that the solicitor will be responsible for costs. And therefore,
yeah, it's very difficult for me to take that in by ear. Would you please send me?
Yeah, I can send you the citation.
And Mr. Doherty presumably has had no notice of that.
No, I apologise. I think we received the statement of costs from the claimants yesterday late afternoon, and again this morning in terms of the updated statement. So this was sort of the 11th hour work to push back on these costs.
Okay.
Yeah. So, but essentially our submission on costs, and again, try and keep it as brief as possible, but the statement of costs filed by the claimants today is that there's additional fees, which are approximately 67,000 dirhams from the original statement of costs, which include significant increase in counsel fees and counsel brief fee, and also notary fees and translation fees. And it doesn't, we're not quite clear why these weren't included in the statement of costs which was filed yesterday. But I think putting this aside, we would refer to Rule 38.18, which states that where the amount of cost is to be assessed on the standard basis, the court will only allow costs which are proportionate to the matters in issue. Now, we would say, also, and resolve any doubt which it may have as to whether costs were reasonably incurred or reasonable and proportionate in favour of the paying party. Sure, you're obviously aware of this, Your Honour, but our position on this is that it's not proportionate to the claim. The claim could have reasonably been resolved without the DFC court's intervention. And as you quite rightly say, you know, in circumstances where there was a dispute, then perhaps CRS could have invoiced the client for those matters, but without incurring the exorbitant amount of costs, which we're essentially in a position where there's been 5 fee earners working on this case and one external counsel. So 6 people on what would appear to be a very straightforward, as my learned friend says, a straightforward straightforward claim. So we would say it is disproportionate and it's not in line with the overall objective. Yeah, they're my submissions.
Okay, thank you very much. I'm going to give Mr. Doherty a chance to respond on the quantum of the cost.
Yes, thank you, Your Honour. I suppose a few points. One of the suggestions being made is that there may well have been some alternate route open to the claimant here. As I'm sure Your Honour can quite well imagine, this isn't exactly a case that the claimant was jumping for joy.
Can we confine it? Let's confine it to the amount of the costs. Yeah.
Certainly, it said there's a significant amount of cost. My little friend pointed to the fact that there was no engagement letter. Clearly, in those circumstances, that was all the more reason for the claimant to keep its cost at a minimum, because this isn't a case where a solicitor is working at the behest of its client who's footing the bill. In assessing the proportionality of the overall sums claimed, it's also important to note what this litigation was intended to avoid, that is, multi-party litigation against CRS and potentially multiple employees, potentially in other jurisdictions. So that proportionality needs to be viewed in the context of the avoided outcome. So where we have a case where an attempt has been made to nip those issues in the bud, when one looks at the overall amount of costs claimed,
we've got 42 hours on documents by someone there. I mean, how do you justify 42 hours on documents?
Well, I suppose that is the point I was about to come to. Your Honour has quite rightly noted the broader procedural history involved in these sorts of cases, the Suntech cases, as you referred to them earlier. Ms. Sheffield has been involved as the partner in those disputes for some time, so has necessarily been involved. But with that in mind, the work that needed to be done has been dealt with as efficiently as possible, and we can see that when we compare the amount of senior lawyer time that goes into work on documents with the amount of junior lawyer time that goes into it. So although Ms. Sheffield has had this long-standing involvement in the case, the claimant has at all times had proportionality of cost in mind. Now, why is that figure as high as it is? Because there was a reasonable amount of documentary and witness evidence to get through. And in compiling that evidence, particularly in response to criticisms raised in the fourth defendant's witness statement that we haven't provided evidence in relation to the court claims, what the compiling of that evidence necessitated was a look into what is a complicated procedural background before the UAE courts. Of course, by their very nature, those documents are written in Arabic. They require to be read, translated.
So why were those documents relevant at all? The only issue is that CRS has received conflicting instructions from separate groups of shareholders via their nominated managers, claiming to control the client. That's all it's about.
Your Honour, we have a great deal of sympathy for that position. But the reason that those claims were looked into and the reason those documents are translated and dealt with in evidence was because the fourth defendant in his witness statement criticised us for not having provided evidence in relation to those claims.
Yeah,
and so it was made to answer that criticism.
That may well be so. He can say what he likes, but so what?
I think the point is that when one is looking at why the costs are as high as they are, it's because that work was necessitated by the fourth excuse me, by the fourth defendant taking that stance.
Yeah, but if he was misguided, then that really doesn't justify it, does it?
One could say that, but the question I think is whether it's been reasonably incurred by my client.
Yes.
And this was an important issue. It was important for my instructing solicitors to get this right, given what was at stake. And it's entirely reasonable, we would say, for a party to seek to deal with an allegation made by another side that it doesn't agree with. So the work done by documents has not only been increased as a consequence of needing to reply to points made by the other side, which, Your Honour, may not have found to be determinative of the case. We are with you entirely on that. We have always been clear that the factual issues that are relevant to the Part 8 are very narrow, but it was the other side who were seeking to open that up. That doesn't mean that the points didn't need to be dealt with and didn't need to be explained in the evidence before the court. And so if we're being criticised for driving up costs, it's only because the other side have necessitated that level of work. And as I say, where that level of work was necessitated, it's being dealt with actually very efficiently indeed by the lowest fee earner.
Okay, I have the point. Anything else?
And simply that when one actually looks at the figures, although there is a discrepancy between the claimant and the defendant, that's almost inevitable in these types of proceedings. We're also dealing with a claim which was intended to dispose of proceedings entirely. So one needs to look at that cost bill, not as though this was some interlocutory application, an application for summary judgment or something like that. This is a disposal. And in that context, we would say that the sums being claimed, the 322,000, are not disproportionate to the issues at all.
Thank you. And those are your submissions.
Yes, thank you.
Thank you both very much indeed. I am going to reserve my decision. You've both given me a lot to think about, and I will think about it. And I will hope that you will have my judgment within the next 7 days or so. Thank you very much indeed.
Thank you, Your Honour.
I wish you both a good day. Thank you.